Senator Samuel.
I want to thank you again, Mr. Vice President. I'm a good soldier. Good soldiers could fight on their own. Don't worry about me. I could stand on my own. I normally do that for life. Don't worry. I don't need any applause. I'm a preacher. Yes, Mr. Vice President. Mr. Vice President. Mr. Vice President. Could I be protected by the noise, sir? Good. Thank you very much. Mr. Vice President, as I was saying prior to the break, it is not so much the issue of attempting to assist 1,000 or so people who are behind bars, but it's whether the system or the offer that is being made by the Honorable Attorney General in his quest to do that is fair enough that will now assist those of the poorer class, which really it is the 100% percentage, 100% of the people who are incarcerated on remand. If you look at the population and the financial status of the people who are at remand, you would recognize they are not of a certain clout in the society. They are poor people. And if the bails that are now executed on these people are not equivalent to their income, is not equivalent to their status, then offering bail to people will also continue to be in the same realm. In other words, they still will not be able to afford it. Mr. Vice President, at the end of the day, we have to determine from those that are incarcerated, those that will present a risk and those who will not. And those that will not present a risk through some assessment can be released because they do not present a risk to the society. But here is part of the bill, Mr. Vice President, that talks about now almost the institution of bail bonds, a bond issued by a licensed financial institution as defined by the Financial Institutions Act. I want to read something from NBC News dated May 12, 2017. It's entitled, "Bail Bond System Exploits the Poor and Undermines Justice." Bail bond companies both weaken and profit from the criminal justice system by keeping poor people in debt even after they have been cleared of charges. It goes on to say that when this article was written, the bail bond industry was some $14 billion annually in that foreign jurisdiction. And they were underwritten by 9 large insurance companies, including some owned by multinational corporations, and perpetuates a system in which people who can't afford bail remains in jail. There is another article, bail, the rich gets bail and the poor gets jail. That's another article, Mr. Vice President. From India, rich gets bail, poor remains in jail. Because the whole system is skewed. As a matter of fact, in some jurisdictions, when judges and magistrates are looking at the bail scenario, they have some kind of information as to the income and the financial status of the individuals that are before them. And it makes no sense, Mr. Vice President, just like the lady who is on $100,000 bail because of a child situation and who needs tremendous counseling. And she can't even probably afford to mind the children. But now you put on $100,000 bail, which she will not be able to afford, in which she will become indebted to, or her family will become indebted to it for many, many, many years. And the cycle of poverty continues and broadens, Mr. Vice President. So really, the articles about bail bonds says there is a fundamental moral problem with profit margins playing such a significant role in whether someone ends up being free or incarcerated. It says bail bond agents are the surety insurance companies behind bail bond systems, and they are there to exploit the poor and undermine justice. Very, very clear, Mr. Vice President. So while we are heading in the direction that appears to sound good in other jurisdictions, these systems that are put in place are reaping havoc on the system. And you know who suffers the most, or in all situations? Those are at the lower financial echelons of the society. So it is important for us to understand that. One writer says in an article from the Wall Street Journal entitled "Cash Bail, a cornerstone of the criminal justice system, is under threat." He says, and that is a senior judge in the DC Superior Court. He says, if we are keeping in jail people on the basis of the accident of their wallet, rather than on the basis of the risk they pose, that just completes irrational folly for us to do so, that a criminal justice system, that as a criminal justice policy. In other words, people remain in jail because of the wallet, or they get out of jail because of their wallet. And it's something, Mr. Vice President, that must be taken into consideration. In the same article, it talks about the bail bond agencies. It says that bail agencies are pouring money into lobbying in foreign jurisdictions. Since 2011, bail bond companies and insurers have donated more than $288 million to campaigns and all kinds of stuff. So they get involved in the politics of countries. And as a result of that, we would find ourselves being owned. The judicial system will be then governed by lobbyists, and they determine a great deal of stuff. Mr. Vice President, it is important for us to understand what we are beginning to legislate, you know. Because it is very easy for the rich to set aside $2 million and decide, I'm going to establish a bail bond company. And they set it up and they work with insider trading, and they understand what the system, how the system operates, and they know who is getting bail and who will not, and what's the kind of bail, and they go by the families, and they have touts who will go about and lobby. Just like how, you know, when a person dead, they have touts who go and look for the body and say, they have touts doing that for dead bodies likewise, and they will lobby, and who will lobby more, and before long, the bail bond company system will be huge and large, and it will be owned by the rich and the elite. But who will suffer? The poor. At all systems that we are trying to deal with in the country, Mr. Vice President, you know who has been suffering the most in every aspect of the legislation brought in this parliament? From motor vehicle to you name it? Poor people. Poor people, more taxes, poor people, more this, poor people, more. And now you're trying to put a system that really doesn't say anything, you know, Mr. Vice President. The system says we want...
Senator, you have 5 more minutes.
Thank you, much obliged. The system says that we want to offer bail, cash bail, to 1,000 people or 800 people who are incarcerated and can't afford bail through some illegal, acceptable bailer. That's how I put it? Because it's illegal, but it's acceptable by the court. And so they're trying to get rid of the illegal but acceptable bailers by now instituting bail bond systems. So you have a legalized system that can now overtake and now exploit people. That is what we are doing here. And then we are saying that is to help the poor. So that helps the poor by putting the poor in more indebtedness, Mr. And they can't afford the little 10,000 or 5,000 to the illegal bailer, but then they have to now find money to borrow from these bail bond companies. Mr. Vice President, you understand the kind of a web that this is creating? It's a web. And the web is only created to keep the poor under the pretense that we are trying to help you get out. But in other words, you may get out, but you get into serious debt for life. That is where the issues are, Mr. Vice President. And if we are not careful, and if we remain as careless as we appear to be going, the system could get worse. And while we want a get-out card, while we believe that this is a get-out card, it might not be a get-out card, really. Mr. Vice President, and I heard people talk about you should not talk about the situation that happened in Malabar. Malabar, that's a grievous system, a grievous situation that took place. But you know, the police said, and I want to just read that in the record, and I'm reading from The Guardian, Thursday, 29 June, 2007. And the headline is Bandit Slit Throat of Woman Teen, Malabar Grief. Police said Mohammed was robbed 8 years ago, and the men responsible were held, jailed, and reportedly released recently. Mohammed's husband confirmed that their home was broken in some years ago, but added that nothing came out of it.
Two things. One, that particular article came up before from another senator in this course of this debate. So what I'm going to ask you too is also to caution you on cases that may come up or be pending in terms of in the court. So I'll just ask you to step away from that particular article and that particular point and continue on as you wrap up your contribution.
And I appreciate your guidance. I was reading it for the record. And for the record, because how are we assessing those folks, seriously assessing those folks that you want to now offer cash bail to? What is the assessment process? Is it because they were offered bail? Or is there an assessment process to determine the type of person that has received bail, but because of the longevity they have stayed in the system, they could be worse off today because of their long stay than they were when they were offered bail in their previous case. And they were offered bail probably 5, 6, 7, 8, 9 years ago, and they can't afford it. And now they are in a system locked away with people who are hardened, locked away with brilliant criminal ideas, locked away with mercenaries, locked away with all kinds of persons. And now that person's mental state is not the same as when they entered and they got bail. Now you're saying to me, offer them cash bail. That person's mental state is not the same. So it's not the same person that you're going to try to give cash bail to. It is something, some kind of assessment has to be placed and taken. And if not, Mr. Vice President, we are heading down a slippery slope. And here what will happen is not only the man locked up going down the slope, it's the whole nation going down the slope, and we will suffer the consequences if we do not put the right things in place to deal with the assessment of people who are now going to be offered this, but who have had bail and couldn't pay because they're in the system. And we have a system that is only breeding wrong. The prison system is not there to breed right. It is not there to change people. It is there to destroy people in Trinidad and Tobago. Every person in the system right now in remand yard is a sufferer. Thank you, Mr. Vice President.
Senator Richards.
Thank you very much, Mr. Vice President. I appreciate the opportunity to contribute to this bill entitled An Act to Amend the Bail Act, Chapter 460. From the onset, I'd like to show the appreciation for quite a bit of the work done by the Honourable Attorney General, who has obviously piloted and championed several causes in this session coming to an end soon. But sometimes I think we need to be careful. Volume is not always quality. And we have done a significant amount of work in the last 2 months in particular But even with that said, I appreciate his vision in terms of the amount of work that he has done or continues to do in terms of trying to re-engineer the criminal justice system. And I also want to put on the record the Hansard, Mr. Vice President. You know, sometimes I get despondent in here, I'll be very honest. And in the last 4 or 5 weeks in particular, I have been given a boost of enthusiasm, and I want to put it on the record because I think it's important before I go into my substantive contribution. Because the level of collaboration I've seen between the Attorney General and Senator Ramdeen in the last 4 and 5 weeks in the committee stages needs to be commended, because I think that kind of engagement cannot go unnoticed and uncommended. Yes, and the contributions of Senator Choate and others, in particularly the committee stages of those technical legal issues, must be commended. I've seen a different kind of engagement, and I really appreciate it, and I want to put it on record. With that said, no however. Some however. You know, I appreciate the vision, Honorable Attorney General, through you, Mr. Vice President, but I have some challenges that I think must be dealt with if I could even begin to support this move. Let me start by using a quote by Dr. Martin Luther King, and I think it's applicable in this state. And it goes, quote, "The moral arc of the universe bends at the elbow of justice." And it's used in the context of atrocities like slavery, where class and race warfare, sometimes justice doesn't serve everyone equally. Our own Constitution mandates equality of treatment under our Constitution. Our anthem has every creed and race find an equal place. We're supposed to have the right of the individual to equality before the law. And sometimes, when in retrospect, the term equality is not the same as equity. There's a huge, they sometimes use interchangeably, but there's a huge disparity between equality and equity. And we have seen that in several aspects of the criminal justice system in Trinidad and Tobago. I have mentioned this before. A lot of what the Honorable Attorney General is trying to do with laws and amendments to laws and bills is predicated on the assumption that institutions are working. Yes. Institutions like the Trinidad and Tobago Police Service, like the prison service, and that is far from the truth in Trinidad and Tobago. It's like having a car that has issues, I used this analogy before, putting the right fuel in place, shining up the outside, and not fixing the engine and thinking that because you do some of the other work, and I'm not trying to diminish the work of the Honorable Attorney General in any way, it's not my intention, that the car is going to work how it's supposed to work. And that is simply not so. We have to fix these institutions. A lot of this bill, in particular my concerns are with 4B and 4C, where the bill seeks to provide for a person acting on behalf of a defendant who has been taken into custody to give security by way of cash or certified check to a prison officer designated to collect same by the Commissioner of Prisons for that purpose, should that person be unable to pay the security, set security into courts due to time constraints. And 4C seeks to provide for receipts to be issued to persons who pay cash or certified checks to a prison officer appointed by the Commissioner of Prisons to receive same, and for the Commissioner of Prisons to cause the cash or certified check to be deposited into the relevant court on the next working day. Now, I won't go over and regale you all with the issues of class disparities and who can afford what, and I underscored the issue of equality and equity before, because as Senator Samuel and others have indicated, we don't all have access to justice equally in this country because justice is expensive. Very expensive. So if you know what's good for you, don't find yourself with an incursion before the criminal justice system. And I want to reference Minister Ambarath in his contribution, always eloquent. He indicated that You know, if we are placing responsibility on the TNT prison service, and if we can't trust men and women who guard thousands every day, we shouldn't have a problem with this. And you know what, Senator Ambarath? We can't trust them. Bottom line, let's not pretend. You, in a contribution last week or week before, said you don't hold favor with a lot of what's happening in the Trinidad and Tobago Police Service for the very same reason. So how is this different? If we cannot trust the TNT prison service in terms of process, procedure, effectiveness, efficiency, accountability, transparency, standards of operation, why should we be putting more responsibility in their hands? Responsibility of this nature? I have a serious challenge with that. Not with the vision for the bill, you know, with the agency that is charged with the responsibility to operationalize this in a fair, just, and accountable manner. I have seen no evidence of standards of operations in the TNT prisons. I had the misfortune, I call it the worst day of my life, Mr. Vice President, to visit Port of Spain prison, remand yard, the women's prison, and I was heartened by the work being done at YTC. So I don't want to lump them in that because quite a bit of good work is being done. But let me tell you something. Any citizen who walks into the Port of Spain prison and or Guantanamo Bay, as they call it, will be ashamed to be a national of this country. Because what I saw has nothing to do with global standards, has nothing to do with restorative justice, and is a cesspit of criminality and indoctrination into a university level of criminality in this country that this bill will not fix. It is unfortunate that we feel that we have any semblance of restorative justice when you have 5 to 12 men in an 8 by 10 cell in darkness with no ventilation, 4 bunk beds, no mattresses or pillows, 6 and 10 on the floor. The ventilation is clogged by muck, and they are out, if they are lucky, 45 minutes in a 24-hour sweep. How can that person be rehabilitated when they come back out? I don't even want to go into the slop pail in this day and age. It is inhumane, it is unconscionable, and it is uncivilized. It takes you back to the days of slavery. The Port of Spain prison should be condemned, closed down. And this is not an indictment on this government or any other government. As a country that's supposed to be civilized, because it has relevance to this bill. It has relevance to this. Because those individuals, if I go in there with all my common sense and my good parents' upbringing, for 1 month, means I come out a normal person. I am not sure I will be the same person, respond to society in the same way, and be able to be rehabilitated. And that is a month. I was sick with 1 day, as a matter of fact, 8 hours. And I don't know how we expect as a country to be treating people in that way, particularly those on remand who are there, if I am understanding it correctly, at the behest of the courts of Trinidad and Tobago. And presumed innocent. And in one instance, someone I spoke to was there for 14 years.
Senator, the issue I'm having is because I'm aware of exactly how you would have come into that information, and as much as you're having it in debate and it might be relevant to debate before us, I just caution you, because you know as well as I how you came into that information, and there is a standing order regarding that. So I would just caution you as you continue on your debate.
I'm obliged, Mr. Vice President. Well, let me change it to the reports I read from Daniel Kahn, and others in terms of the atrocities, and not my own experience. Because the Daniel Kahn report, which I agree with the Honorable Attorney General, is verbatim the same thing I'm describing. So I will reference the Daniel Can report. I'm much obliged, Mr. Vice President. And we need to fix that as a standard of operation. I want to stay also on the TNT prisons, because this bill, as I said, puts more responsibility on an institution that has shown that it's lacking responsibility. And reference the report I had the honor to lay on our last sitting, the fourth report on the Joint Select Committee of National Security into the Port of Spain prison break on July 24, 2015, where in spite of that report, I don't think the population has gotten the answers they want as to what happened, how it happened, who is or is not responsible. And I will tell you that if we do not get to the bottom of that, it can happen again. A police officer lost his life in that jailbreak. And we don't know who is responsible, if they are still stationed there, if he or she had accomplices in there, and at worst case scenario, if there was dereliction or neglect of duty in terms of securing that institution. So I am not comfortable with putting any more responsibility in the hands of anyone at that institution, as is mandated or suggested in this bill. In addition to that, and I can offer this as a suggestion to the Honorable Attorney General, in 4B and 4C or elsewhere, I am seeing no indication with that increased responsibility, Mr. Vice President, of increased penalties for breaches by prisons officers commensurate with this increased responsibility. Well, coming is not here. And I have a problem with that. Because if these individuals, and I'll draw a scenario, this bill, parts of this bill without those caveats, is really a business model for malfeasance. Imagine a bright prisons officer, because we are creative people in this country, Mr. Vice President. $10,000 at the lower end of the spectrum, in or out of collusion with a leader of a gang who has access to hundreds of thousands of dollars. Get bright and realize, you know what? The system in place. All I need to do is get $30,000 and have it on standby. Somebody come in, boy, I have the money, see what you can do for me now. I'll go post your bill for you, $10,000. Give me a 25% interest on that. Pay to X and Y. This is a real scenario. This can happen without the caveats for increased penalties, because we know that in addition to the prison break that took place that day, cell phones and marijuana are common trade. Laptops, iPads, television sets, and in some cases, I don't want to call them contraband, but I understand individuals make their way into the prison for entertainment purposes, and that's all I say.
And officers too.
Okay? So do we want, without answers and accountability where those issues are concerned, at something as so critical in the criminal justice system as the prisons, without answers, remedies, and accountability, to put more responsibility into these individuals' hands or into this institution's hands without the necessary checks and balances, without the answers we need, without the accountability we need? I don't think so. I am not comfortable with that. Mr. Vice President, I have seen this Honorable House do what I will describe as legislative gymnastics regarding bills brought by the Honorable Attorney General in committee stage to put 1 million checks and balances in place because we don't trust the police, and spend hours after hours because we cannot reasonably. We know all institutions will have some level of corruption, but we cannot reasonably trust the police not to be malfeasant. So the amount of legislative gymnastics we have to go through, caveat after caveat, because we can't trust the police service, because no significant headway has been made in terms of identifying the levels of corruption and thwarting it. Similarly with the TNT Prison Service. And that, I think, needs to be where our heads are at collectively in this Honorable House and in the other place. Because we cannot simply say and comfort ourselves by the statement, well, it's only the minority. Based on what? How do we know that at this stage? How do we know it's the minority? We know they are hardworking honest police officers. We know they are hardworking prisons officers. But we don't know it's the minority because I'll tell you something, Mr. Vice President. I'm not a legally trained mind, but I know that there's an element of complicity if you see something wrong happening and you don't say something. And several times, as with the prison break, as with other issues in the prison service and the police service, officers may not be overtly involved, but they will know what is happening and not report it. And that is a level of complicity that I am very uncomfortable with. And I know, if I'm not mistaken, it's against the law. These things have to be repaired. Because you know what? It's interesting that yesterday, Mr. Vice President, we had the SEA results coming out. And 15% of those who sat the exam, 15% did not make a 30% passing grade. And we are boasting about we have made improvements at a 30% passing grade. How globally competitive is that? That our passing grade in Trinidad and Tobago for transition from primary to secondary school is 30%. Whoopee! Pat ourselves on the back. Let's move forward. We're going to beat Japan and Singapore. With 30%? But with 30% passing grade? Okay, all right. That's my point. And I keep saying, when you have such a significant level of, I don't want to say failure, but lack of performance, it is not the children, it is the system. It is the system that is failing them. And I will make the link to the bill because more than likely, because of research done, seminal research by Professor Ramesh Desaran, Professor Selwyn Ryan, those are the ones who are going to have to option this. Those are the ones who are going to have to end up in the criminal justice system with incursions and option bail. Because we're not fixing that also. Because we want to focus on the 3 bright kids and parade them around town. And that is not exclusive to this administration, so let me not even say that is a party or politics thing. It's a general practice we have. We need to fix the education system. And 30% should not be our benchmark for claiming success. Because if we have 15% not making 30%, if you do an exponential curve, you more than likely have 20% or 23% not making 40%. 30% passing grade basically in a large, wide sense tells you that student has 30% competency in the subject matter. Does that make sense? Is that student really able to cope with Form 1? And then we pass some others who didn't make 30% on to secondary school. They're going to struggle and end up having to option this very same bill because society has failed them and they end up falling through the cracks, or rather the cracks swallow them and end up with incursions in the criminal justice system. This is not an holistic way to move a country forward. It is not. And as I will say again, I am not laying this at the feet of the Honorable Attorney General. I think that his vision for the re-engineering of the legislative options in Trinidad and Tobago is admirable, but it has to be in an holistic sense. And it has to also be, Madam President, based on some sort of reasonable confidence in the institutions like the prison service, like the police service, to operationalize these with some modicum of trust and confidence in the public. And right now, that is not the case. And we have to address that. We need to look at those institutions and fix them. If we don't, we will constantly have to come back to this honorable house and the other place to update legislation to deal with an ever-increasing criminal cadre in Trinidad and Tobago, and even more sophisticatedly so. When we look at the presentations of honorable senators today, and last time we met, we have seen the kind of creativity and loopholes that can come, though well-intentioned, because of what has transpired before in terms of people finding loopholes with the law. This is no exception, and we need to be forward-thinking and deal with it so that we do not have to constantly come and invent laws and amend laws and be 5 steps behind the curve. Because that we seem to be constantly playing catch-up in Trinidad and Tobago. When you think of what has happened, and as I said, I'm heartened, Madam President, by the fact that we seem to be moving forward by a meeting of the minds with contributions, the collaboration between the Honorable Attorney General, Senator Ramdeen, Senator Truce, and others, that we now understand that in legislation such as this bail amendment bill, we need to put timelines in place for reports and not leave it up to agencies to give reports as they feel. It took almost a year to get any semblance of understanding of what happened with the prison break. And if this bill, in terms of the intricacies, record keeping, 4D, would seek to provide that the Commissioner of Prisons ensure that a proper record of all bail monies received is kept. A record when, and how, and in what format, and due when. That I am not inclined to leave those subtleties open anymore, Madam President, based on what I've seen in terms of agencies charged with these responsibilities, because they have proven time and time again that they're not only not responsible or irresponsible, but in many instances they are fraught with corrupt agents who can creatively, very easily thwart the system, which presumes some level of honesty and competence. And from what I have seen, with many of the examples I've outlined, all I'm seeing is largely incompetence. And further to that, corruption, overt corruption. When we look at one of the aspects I'm also concerned with in terms of and I won't go over the vicissitudes of it because many of the other speakers have also dealt with the issue of access and equity of access in terms of the wealthier being able to post bail, get the checks made, and thereby, not only that, as indicated earlier, $100,000 to somebody who is worth $50 million is nothing for freedom. And I asked Senior Counsel Choate about this because she's a legally trained mind. If there is any time limit on bail, given the long remand periods we've had, and it's quite conceivably that someone could have an incursion of the law, be granted bail, and be out on bail for 15 years because I can afford it. And it's happened. We need to put caveats in place to take care of all of that because they are realities in Trinidad and Tobago. And just depending on goodwill and honesty at this stage is not good enough. I want to draw an example, Madam President. I hope I'm not stepping over the line because it speaks to incompetence in the system and the cost of incompetence and the cost of unchecked corruption and the cost of unchecked efficiency, whereby, and it goes to, just like the prison systems, with the level of lack of accountability, the police service, and the fact that the Honorable Prime Minister was forced, because he's educated, he's experienced, he's an astute politician, to revoke an appointment based on information he has at the National Security Council level, that the police can't convert into intelligence on somebody who is of interest to the state. He was forced to make a decision like that. I'm obliged. But it speaks to what even someone in a senior position has to deal with because agencies can't do their jobs. And that is a sad indictment on this country because we can't even, at a basic level, with all the accolades about police and most of the police are good, if we don't understand or know how many are corrupt in the police service or the prisons, how can we make an assumption of how this bill and others of its nature will work? How can we make an assessment honestly and objectively in a scientific, measured way of how much corruption is in the system and how much this corruption will affect the implementation of this and other pieces of legislation? We're basically shooting in the dark. As well-intentioned as the Honorable Attorney General is, putting legislation in place, trying to re-engineer the legislative framework in the country. If we don't arrest these situations, we are basically shooting in the dark, and all this work will amount to naught because agents who are hell-bent on malfeasance will continue to thwart the system and become rich and, in many instances, cost lives down the road. And I didn't intend to be long today. I just thought it was very important that I elucidate these points. The prison service is there to house inmates who have been convicted and who are on remand for security purposes, which is critical for the national security grid in the country. And I disagree with Senator Hamdeen in his contribution, who said it is a prison. We need to change the mindset from prisons to corrections. The mindset of the word is critical because more than 80% will return to society. And under the conditions they're presently being kept, they are coming out worse than they went in and creating more havoc and costing the state more and more. And those are the same ones who, in many instances, will benefit from this, as opposed to providing the kind of intervention that I believe the Honorable Attorney General has in terms of his intention for this. I want to close, Madam President, by using a quote again. And it goes, "Injustice anywhere is a threat to justice everywhere." And that's, once again, Dr. Martin Luther King. When we have, as a country, and we accept the injustice that's being perpetrated in the prisons because of corruption, we met out to ourselves the injustice that we're feeling now in terms of criminality. It is a revolving door, it's a cycle. We need to change the system. We need to address the police service and its inadequacies. We need to address the prison service and its inadequacies and other critical institutions, including the judiciary, that will have to operationalize these pieces of legislation and try to move our country forward. With those few words, Madam President, I thank you.
Oh, Senator Coppin.
Thank you, Madam President, for the opportunity to contribute to this debate on an act which is cited as the Bail, Access to Bail Amendment Act 2017. Madam President, this bill is a mere 6 clauses with 1 schedule. And if we look at the bill in its entirety, really, it's only about 3 clauses and the schedule. In fact, it's a very simple piece of legislation. And Madam President, I want to start in a slightly different manner from my previous contributions by saying, very first, what this bill is not about. And I will, in the course of my presentation, return to these issues. Madam President, this bill is not about legalizing professional bailers. It is not about preferential access to the wealthy for bail. It is not about creating the right to bail for repeat violent offenders. And it is certainly not institutionalizing or creating a new system for banks to issue bonds. And Finally, Madam President, it is not an indictment on the prison service. Madam President, what this bill is about is rooted firmly in a statistic that the Honorable Attorney General would have pointed out or would have given to this Honorable House in his opening and also in the other place. And it is a statistic that we in the Joint Select Committee on National Security last year would have inquired of the Commissioner of Prisons. And in his response to us, in a memorandum dated December 6, 2016, he would have indicated, Madam President, that the number of remand detainees who have been granted bail but have been unable to access bail is in the tune of 764 adult males, 3 juvenile males, and no females. Now, Madam President, that is much different from the number of remand detainees who have been charged with non-bailable offences, and those offences are listed in the first schedule, Part 1 of the Bail Act, and those persons are those persons who have committed offences such as murder, treason, piracy, hijacking, and any other offence for which death is a penalty fixed by law. Now, Madam President, it is also not about those detainees who have been charged with bailable offences but have been refused bail by the court's discretion. And those are those individuals who Section 5(2) of the Bail Act, and who I think Senator Sturge, when in his presentation, regaled this House or tried to create a sense of fear or panic that violent offenders, repeat offenders, were going to be released. Madam President, those individuals are listed, or the category of those individuals are listed in Part 2 of the said schedule, and I give some indication of those types of individuals who we are not speaking about in this bill. Those individuals are repeat offenders, those people who have three offences, or three in separate occasions, 4 offences such as possession and the use of firearms and ammunition with intent to injure, shooting or wounding with intent to do grievous bodily harm, robbery, and robbery with aggravation, armed robbery. So this bill, Madam President, is not concerned with those individuals who judges and magistrates have no discretion, those murderers, to grant bail, and it is not concerned with those repeat offenders who Senator Sturge has come to this Honourable House and says we are trying to release. It deals simply, Madam President, with those individuals who the courts say the magistrate or judge has a discretion to release. And, Madam President, I want to repeat or to elucidate on some statistics that were given to us in our Joint Select Committee responses. And those individuals, or those type of individuals, to whom are locked up in remand yard for no reason, save and except that they have not the wherewithal or the means, those individuals are charged with simple offences such as breach of immigration regulations, breach of motor vehicle regulations, breach of the Bail Act, breach of Forestry Act, imagine, breach of a protection order, breach of the persons who threw missiles, persons who used obscene language, persons who were loitering, and people who were found on lands. And those total of the 700 and odd persons I just mentioned, those individuals are counted as at December 6th for 149 individuals. Now, Madam President, we must therefore understand that this bill is not about letting violent persons out on the street or those persons who ought not to be there. And, Madam President, I listened to the debate in the other place. And, Madam President, I think for once, they in the other house were much more spot on than we were in this house. I think we opened up this debate in a manner that it really ought not to be opened up, Madam President. In fact, with 3 substantive clauses, Madam President, it the duty was on us, the simple task was on us, to consider those clauses, Madam President, and to deal with them in a way that they ought to be dealt with statistics, using the statistics that were available, and the experience that we have in the criminal justice system. So, Madam President, I want to speak about those individuals who were granted access, but for whatever reason, because of the current law, were unable to access bail. And Professor Diosaran tells us in 2003 that the type of individual who is most likely to be incarcerated, or who is incarcerated in Trinidad and Tobago, 97% of those individuals come from low-income households. That's a key statistic. 97% from low households. And, Madam President, that's a 2003 study. And when we understand and when we look at the bill essentials, it is very clear, the simplicity of the bill, the mischief that this bill seeks to address, is quite clear. That notwithstanding the fact that judges apparently can grant access to bail or give bail in cash, for some reason they chose not to. Now, Madam President, I want also, before we get there, because Senator Sturge raised the point about judges arrogating, or magistrates arrogating unto themselves powers. Now, Madam President, if we look at the Bail Amendment Act, and all senators should have in preparation for this debate, what we find is that nowhere in any of the sections, namely Section 12, does the bill actually enumerate or say what the magistrate's power, what forms of bail the magistrates can actually grant. So the first thing this bill does is to, Madam President, to remove a lacuna in the law. That is to say, something that is missing from the law. Because if the magistrate has no legal foundation for granting cash bail or bail in any other form, then the question must arise, where does the magistrate get this power from? So the first thing this law does, it enumerates the types of bail that can be granted by a magistrate. And it's interesting, Madam President, because when we look at the schedule, the second schedule of this bill, the form of recognizance, we see that the magistrate has the power to grant certain types of bail. It's not in the actual body of legislation, but we are only given an indication in the second schedule. Now, Madam President, that's a problem, because we have a law where it's unclear. We don't know where the power comes from, and the only indication we have is what the judges currently do and what is in the schedule, which is not clear. A schedule is not something that is in the body of the law. Now, for lawyers, for those who know about the law, that's a serious problem. So this law fixes a number of lacunas in the law. Now, Madam President, when we look at the judiciary's website, this is what was published. We see that the judiciary tells us the types of bail that magistrates can grant. But again, there's no legal basis for that. So the judiciary effectively, again, has not only arrogated unto itself a power for which there is no legal basis, but they have now published it. And the honorable opposition leader in the other place would have pointed to this. She says, why are we here? Why are we even talking about these powers when the judges and magistrates already exercise it? But I think, Madam President, that that's a misguided approach. If something is broken, we must fix it. And I must congratulate the Attorney General, because the bill has been on the books for so many years. But no other Attorney General had the foresight to do a simple amendment which would give the legal basis for magistrates to actually grant bail. So, Madam President, those are the two issues that I would have liked to raise, and it dealt with the access to bail for those persons who required. And as a Tobagonian myself, the issue of landlessness, it was brought up by the temporary Senator Moore when she was here. The issue of judges granting bail to those persons who possess land only is a serious problem for Tobagonians who only 17% of the actual population is in possession of title. But, Madam President, the problem is not localized in Tobago, because one joint select committee on the issue dealt with the issue of landlessness in Trinidad and Tobago. And I'm sorry, Senator Small is not here, because in that joint select committee on local authorities service commissions, the first report, inquiry into the Land Settlement Agency in relation to squatter regularization, we were told, the population was informed, that 55,000 households in Trinidad and Tobago currently don't have title land. They are squatters. When we extrapolate that, according to this report, it means that 200,000 individuals are landless in Trinidad and Tobago. When we juxtapose that against the numbers of persons who are currently applying for HGC houses, in the last administration's tenure, 2010 to 2015, 200,000 persons applied. The problem is more acute for young professionals like myself, Madam President. Very true. If I get locked up, who is going to bail me out? My friend? No, because most of my friends are also landless, are without property. Senator Sturge would have told us that the problem is also acute for those persons with leasehold lands. So the courts appear not to want to accept persons with valid leasehold titles. So, Madam President, we have a certain arbitrariness that pervades the entire system, that this bill, I think, with its by enumerating what the courts can and cannot accept, in the figures they can and cannot accept, will go a long way in helping the magistrates in the exercise of a discretion, a power that they appear to have arrogated unto themselves. So, Madam President, that is the sociological context. That is the problem that currently faces those persons in remand yard who are not the violent offenders, the persons who are guilty of obscene language, persons who are guilty of minor offenses, but through no fault of their own, cannot access bail. And that's what this bill is about. Now, Madam President, Senator Rambarat would have touched on the point that this bill does not trample or it does not amend Section 5 and 6 of the Bail Amendment Act. It is quite clear that there are certain offenses which there is no bail, there are certain offenses which the court has a discretion, and it clearly enumerates the way in which a court needs to exercise such a discretion. Now, Madam President, I started off by saying what this bill is not about. And much has been said about the right to be presumed innocent. That's a constitutional right enumerated in Section 5F1, I believe, Section 5(2)(f)(1) of the Constitution. And that's the right to be presumed innocent. And that's a right, no matter where you are, rich or poor, that must be afforded to all, equality before the law, Madam President. So for those individuals who somehow have come to this Honorable House with a notion that persons who are wealthy ought not to be provided with same access is a misguided notion in law, notwithstanding the fact that we may have a certain amount of disdain for persons with wealth. It is not enough to say that those persons should be treated any more differently from persons who are landless. And, Madam President, if we were to follow or to take that suggestion on board and were to pass legislation that would entrench a system of inequality in the law, I am sure that the first persons who would go to the courts would be United National Congress. They have a certain propensity to come to this House, say one thing, and to do another. And, Madam President, I say that to say that the issues in the other place were quite narrow. And somehow, notwithstanding the fact that we are almost at the end of term, a certain amount of politics was brought into this bill. And, Madam President, just today, I woke up and I do as I normally do. I read the newspaper. And there was a certain article about a lady who was granted bail. She was charged for fraudulent qualifications. She posited herself as someone who had a certain degree. She was working for I think it's a regional health authority. And she was granted bail in the sum of $150,000 surety or $15,000 cash bail. So that's the approach the courts normally take. It's either they give you a big sum for surety or they give you a smaller sum, like a fraction, 10% with cash. Now, a lot was said by persons on the other side about persons walking to the prisons with a bag of cash. Now, it's obvious they have not read the bill, because this section 4 of the bill clearly states that if the sum is over $10,000, the court would only accept, I think, certified check. So it's not a question of a person going with a bag of money to the prisons, going and the risk that poses. Someone who, only those individuals who have been granted cash bail of less than $10,000 would be given would face those types of risks. So the question remains, therefore, and in those circumstances, they can also give certified check. So it's not it's mind-boggling to me that persons would come to this honorable house and try to confuse the conversation, to obfuscate, Madam President. Now, Madam President, I want to deal also with a criticism that was raised by Senator Mahabir. And I think, as eloquent as he is, persons took the suggestion and I think they ran with it without understanding the true implications of what he was saying. The system of bail bonds is not the same as bonds issued by financial institutions. It clearly is not. A bail bond is a sort of agreement that is entered into. It's an agreement. And if you follow the American system, a bail bond is an agreement whereby persons enter into an agreement with a bail bondsman for the repayment of a certain sum over time. A bond, however, is a financial instrument, a security. And if we understand, because if we read the Securities Act, we will see in a particular section, the definition section, that a security, a bond is also a security. So they're two different things. It's not that banks are going to wake up in the morning and somehow want to give security to persons who are charged with a crime. That doesn't even make sense. We know how risk-averse banks are. Could you imagine a bank suddenly wanting to, a financial institution wanting to get into the business of lending to persons who are likely to flee? What is the interest rate going to be on something like that? So I say that to say, it is not that there's going to be a system of financial institutions going to somehow get involved in bail bondsmen. And in fact, Madam President, we would understand that because securities are regulated by the Securities and Exchange Commission. Bail bondsmen are illegal. So there's a clear dichotomy in the two. One is illegal and one is not. And this act in no way, shape, or fashion tries to legalize the bondsman, the system of bail bondsmen in this country. It is clear. So I think when I read the newspaper this morning, that article also jumped out at me. I know Senator Small, he has a certain aversion for banks because he understands sometimes that they are less than forthright with persons of low income. But they are two different systems. And I felt that, Madam President, I could not allow that misinformation, as well-intentioned as it may be, as Senator Mahabir, as he has a brilliant mind, but he surely does not have a criminal mind. So,
Will the Minister give? Thank you very much, Honourable President, for the member giving way. Honourable member, you see, the concern I had, and just for clarification, it says a bond issued by a licensed financial institution as defined by the Financial Institutions Act. And as far as I'm aware, the only bonds which are issued by any one of these licensed financial institutions is a bond issued by the Home Mortgage Bank of Trinidad and Tobago. Could you advise me on which other institutions offer the bonds to which we are referring, which will then be used for the purposes at hand?
The Attorney General has informed me that he will deal with such a situation.
Thank you very much, member.
No problem. But, Madam President, as is apparent, and the Attorney General will deal with it, bonds are, as I said, financial instruments, and these types of bonds, I know they are performance bonds and those sorts of things, but I don't believe that this is what is meant. I think Hindu Credit Union, for instance, and CLICO, these institutions would have, when they were got into a certain amount of trouble, certain bonds were issued to depositors. In the case of the Hindu Credit Union, those individuals with $75,000 and up, whereas I think in CLICO it was the sum was $50,000. So those institutions, there's a number, there's the circulation of those types of bonds in the economy, and persons are sized of those types of bonds. And what this bill essentially does, in my estimation, it gives holders of those types of bonds to pledge them for the security of persons who are in need of bail. So it just broadens the types of categories of individuals and literally access to those individuals. And you would be surprised, Madam President. I once had a client who had no money. He came to me. He's a high net worth individual. He had no cash, but he had quite a lot of bonds. So you would be even amongst the rich, Madam President, there may be a liquidity problem, but those individuals have a certain access to other types of financial instruments, which may be used for the grant or access to bail. So, Madam President, I thought that I just needed to clarify that piece of what I would say a mischaracterization of what this bill sets out to do. Now, Madam President, I don't want to be too long. However, I want to raise an issue that Senator Sturge would have raised as well. He spoke about conditional bail. A number of speakers would have raised the fact that the Electronic Administration of Justice Electronic Monitoring Act, which allows the certain bracelets to be placed on individuals, is in fact law in this country. It is not operationalized. In fact, in our Joint Select Committee on National Security, I know Senator Richards could testify. We were quite flabbergasted and shocked when we learned that only this year they had set up, or last year, a certain implementation committee to get that piece of legislation off the ground. And in Section 8 and Section 10(2) of this Act, Senator Rambarat would have raised it. There is provision for, as a condition of bail, certain monitoring devices to be placed on individuals. So it is not that we didn't contemplate, or that this bill alone is what this government plans to use as a condition of bail. But, Madam President, it is clear that for those who understand and have a full understanding of what is going on in this country would know that certain steps are afoot for the implementation of these devices. So I thought that's just another misinformation that was out there in the public domain that needs to be addressed. So, Madam President, in wrapping up, I would like to say that this bill is not meant to guard against fantastic possibilities. It's not everything we can legislate for. But, Madam President, we can surely do all within our power to right the wrongs, to fix the lacunas in the law, to bring consistency to the exercise of a certain discretion that magistrates seem to have arrogated upon themselves. We can do all in our power to ensure that the constitutional right to equality before the law and the right to be presumed innocent. And, Madam President, there is actually a right to bail, to the access of bail, in Section 5F23 of this Constitution, What that means, Madam President, has never been truly ventilated in our jurisdiction. But what we can say, Madam President, is that no one is supposed to be denied bail except for a just cause. And having access to wealth, to money, to land is surely not a just cause that can be justified in this society. So, Madam President, I thank you for the opportunity to contribute. I hope that I have addressed a number of concerns that persons and misinformation that has been permeated in this debate. And I hope that honorable senators will do all in their power to right the wrongs that have been perpetuated in this land and to support this bill. And I thank you.
Senator Edwards.
Now, Madam President, I thank you for the opportunity to contribute to this debate and act to amend the Bail Act. And I just want to start off by saying that while the bill is not about a number of things that would have been articulated by Senator Coppin, which he is right, it should be about some of the things that he mentioned. Because we do have an approach, and I would say this, in the lead up to today, I was speaking to a colleague who asked me what we were debating, and I said to him it was an amendment to the Bail Act. And his response to me was that in Trinidad and Tobago, we're always debating some amendment here, there, and where have you. And it is true. We have to update our laws as time goes by. But the fact is that we need to be able to treat with things in a holistic manner as far as is possible. Because we cannot be coming and making amendment upon amendment upon amendment and not getting it right. So therefore, I do wish that this bill would have been about a lot more than it currently is, to ensure that we get the system right. That is the only way that we can fix this judicial system. Because the fact is that while the Honorable Attorney General would usually say that we have pieces of legislation coming, as Senator Richards said, coming is not now. We need certain pieces of legislation and amendments taking place at the same time. Now, jumping straight into this debate, as has been ventilated time and time again, because I would not go into depth in terms of a lot of the things that would have been said. Now, cash bail paying, there should be an option for persons to rightfully be able to pay with a card, debit card, credit card, whatever the case is, especially in cases where it is below $10,000. I am not so moved by the whole discussion about persons walking with a paper bag of money and stuff, because I don't really see that taking place as being said in the manner of that taking place. But the reason why I would want to see persons being able to pay with a card or so on and so forth would be for the accountability and the transparency that may be involved in that process. Because the fact is that when someone comes with $10,000 or how much ever money, no one really does a check on where that person would have gotten that money from. Now, if someone had to put that money through a financial institution, then they would have had to explain their source of funds. And then you would have a certain level of accountability taking place where that person has to justify where this money is coming from. Because it may very well be a situation where the reason a person was arrested, they benefited from that whatever scenario, and that same money is what they're using to get bail. So we have to put systems in place to ensure that that money that is being used as bail is accounted for. Because what we would have is just that continuation of a system in place that fuels and encourages corruption in this country. Now, Senator Creese stressed that plastic is here, and I want to stress that as well. Recently, Jamaica would have announced their whole decision to go the route of an e-government. Trinidad and Tobago, we are lagging behind. And we need to ensure, in the sense that everything that an individual, every service that the government offers, a person should be able to walk into an institution and pay with their card. I can assure members that going into the registrar's office, where you have to pay to register a business, For the longest while, there is a sign saying that the links machine is not working. And when we go into many other offices, government offices, we are not allowed to pay for certain services. We should be able to even do this online, as the case may be. But I digress. The fact is that we need to do better when it comes to how we handle money in this country. Persons should not have to be walking around with money when they don't need to. Now, when bail is forfeited, why do funds go into the consolidated fund? What I'm coming to realize more and more is that all the funds, all the taxes, everything just simply goes into the consolidated fund. Why can't some of that money that is being received on the judicial sector be used to improve the judicial sector? We have prisons being the way that they are. You can pass in front of any prison in the morning and see crowds of people standing there waiting to see their relatives, and they have no place to shelter. They have no place to be seated unless the gates are open and they are allowed in. So the facilities are horrible. We should be using some of that money to assist the judicial sector in moving forward. And then, and only then, we can really talk about separation of powers. Because as it stands, the judiciary is heavily dependent on central government to ensure that it can move forward and implement projects. It does not have the sole discretion to implement projects as it would like to. So I would really want to see funds, some cut of the funds or so, being put very specifically toward the improvement of the judicial sector, especially in cases where we're accepting it as someone's bail being forfeited. Now, the whole idea of recognition of professional bailers have been coming up throughout this entire debate. And the fact is that we do need to regularize that system. We cannot continue to acknowledge that we have this side industry taking place and just walk around it and give it a side eye. Because that is what we're continuing to do. We're continuing to acknowledge that they exist, but what are we doing about it? And the perfect example of how that kind of thinking has failed is licensing office. Because we know for a fact that there are licensing officers accepting money on the side to process licenses and so on and so forth. So let's get down and deal with it. I remember I went to San Fernando San Fernando Boys RC, so on the promenade there, and passing the San Fernando Magistrates Court every day, and I would see all these people outside and not knowing what they're doing there. And it's only after time that I've come to realize, well, those are the persons who are trying to get clients, right, to be able to provide that service of being a bailer and so on and so forth. And years after, I mean, the fact is, yes, I'm not that old, but years after, the system still remains and you still have all these persons outside. So what have we done since then? What do we plan to do? We need to fix that system. We need to regularize it. This way, when the whole idea of 10% being paid to the bailer, that has now gone out of the window because persons are paying more than 10% in some cases, 20%, 25%, 30%, and upwards on the value of the property. And that is something that we need to regularize if we are to move forward. Now, the bill does nothing to make people safe and secure, according to Senator Solomon. But I would want to disagree. Because getting the bail bill right would assist those who deserve to be on the outside get there. And also, we know of stories of persons being held in remand for years only to be found innocent later. And what happens in those instances? You have persons coming out of the prison system, hardened criminals, and they feel that they must now seek out justice against the society that they feel has put them there. So if it is that we don't have the bail bill correct, then you're going to have these persons coming outside and posing a bigger threat to society. So I do see it as something necessary to correct, and we do have an opportunity to correct that here. And so I do think that it is worth our while in that sense. Now, the whole argument about it being right to allow persons to get out of the system or behind bars unjustly can also be used when we think about persons who are actual criminals and are being put back onto the streets. The fact is that you have many persons who, after they've gone through their trial, they are found guilty, and we come to the realization that, yes, you know what, this person deserved to be corrected or deserved to be penalized, as the case may be, for the wrong, even though I do firmly believe in restorative justice as opposed to retribution. But the fact is that we need to ensure that the system is efficient, because you cannot have persons up in the air about what their future is going to look like. We need to have a system that is responsive to the threats to our peace of mind, safety, security, and that of the victim and offender involved in this process. Because a person, and one of the things that bothers me is that these persons would be simply accessing their bail and then going out, coming back out into society. But what is put in place to really capture data on these individuals or to really make an intervention where it's necessary? If a person is held on domestic violence charges and they come, they get arrested, or what have you, they receive bail and they're back out there, have we done anything to fix or prevent a situation like that from reoccurring? And the answer is no. We should be able to make an intervention there. So as opposed to a person simply accessing bail and then going out on the outside, let's put some more provisions in place where we can actually make an intervention and prevent the cycle of crime taking place in our society. Because we've seen time and time again where persons come out and there is a revenge attack. We see situations where domestic violence takes place and the husband or the wife, the accused returns to the household, and then you end up seeing the spouse of the accused murdered. We had a prime opportunity to fix that or prevent that from happening. And the same thing goes with persons on drug charges. Why don't we make an intervention at that point to ensure that they get the help that they need? As opposed to arresting them now for the possession of drugs, and then when they've accessed bail, they're back out there involved in the same thing that got them there in the first place. So what I'm saying is that we have an opportunity to make a proper intervention, and as it stands right now, it seems as though this is not being allowed through the whole idea, the whole concept of bail, which is to allow someone to be on the outside ahead of their matter actually being started. Now, also, I don't fully agree with the whole idea of bail being pegged on simply income. Many other factors should be taken into consideration, and some of them could be a person's educational background, thereby lending to their ability to...
Senator Edwards, the matter before us, the bill that we're dealing with, is dealing with one aspect of bail, which is talking about the issue with cash, checks, that sort of thing. It's not about everything about bail. And what you're doing in your presentation is you're talking about everything about bail. You're giving a treatise on bail. But you need to limit it to the matter before us, the bill before us, okay?
Thank you, Madam President, and I'll be so guided. Now, getting back to the bill before us, one of the things outlined is that an officer would be able to receive the bail and thereby issue a receipt and what have you. But the whole argument has come up time and time again about trust and these things. And I am not one to go out there and say that I don't trust the police service and the prison service and all of that, because I do think that I'm doing an injustice if I go down that road an injustice to all the hardworking police officers and prison officers who live right and who do things by the book. So I will not put that entire sector into disrepute whatsoever. What I would say, though, that therein lies an opportunity through this clause that a whole other industry, an underground industry, can be started. Because persons can now solicit funds from those who come forth to pay bail, asking for something on the side and asking them to come forth with something extra to ensure that everything is processed. And the fact is that there are many persons in this country who do not know their right. They do not know their rights, so they will go into a situation thinking, well, you know what, this is probably something that I have to do. And then you have someone else telling another individual, well, if you go and pass a piece of this or whatever the case is, you will get through. So how then do we prevent those things from taking place? I'm not saying that it is not a provision that we should not have, but at the same time, what measures are we putting in place to ensure that instances of wrongdoing and corruption do not take place moving forward? And one of the other things is that the whole idea of persons not being able to properly fund or come up with the money for their bail and what have you, and this being pegged on their circumstance, I do think that those individuals, a lot of the times, are what we perceive as being the small fish, and they actually have supporters in the background, the big fish, who will fund them to come out, whatever the case may be. And those are things that we need to also look at to ensure that we find ways and means by actually solving the issues that come about. And this is where this bill can actually play an integral role. Going back to that whole idea of source of funds and so on, I do think that we can make a proper intervention. So, in a nutshell, I'm actually happy to see that we're making amendments to this bill. However, we need to do better. And we need to stop coming with small changes and look toward bigger changes that would have a greater impact. Because the fact is, there are so many other things that need to be fixed. And there are so many persons right now who are in our prisons, who are in remand, who are there for years and what have you. And they simply cannot come out because they cannot access bail through the right means. And we do not want a society that encourages, and especially because of a laissez-faire approach, that encourages persons to seek out loopholes and other means to access bail in this country. So I welcome changes, but we need to do better, and we need to look at the bigger picture as we move forward in addressing the issues that impact on our judicial sector. And with those few words, I thank you.
Senator Heath.
Madam President, thank you for the opportunity to contribute to this bill, an act to amend the Bail Act, Chapter 460. Madam President, the perennial problem with bail is that persons who have gotten bail and are not able to access the bail itself becomes punitive in that they essentially serve a sentence, not having gone through a trial. Now, the thing is, if a person comes before a court and either A, he is not granted bail, or he has been granted bail and cannot access bail, the usual alternative is to get that person to a speedy trial because of the fact that he's incarcerated. This, of course, becomes even more important when the offense is of a trivial sort of nature, because the offense might very well attract a fine or some non-custodial sentence. So if it is there he is not able to access bail, he is essentially doing time. Now, the system of the professional bailer is, in my view, a necessary evil in that there is, in my view, an inextricable link with this system and the number of persons who have been able to access bail and come out. And that is to say, without them, we would have even more persons in the prison system. The problem is, the system is illegal. To a large extent, persons in the criminal justice system turn a blind eye to it. So, for instance, as an attorney at law, I inform my clients that there is such a system, and I tell them, but I'm not getting involved. You are on your own. Because a number of persons have been burnt by the system. So this professional bailer, who is really a facilitator, who has a catchment of persons who have valuable security, usually a deed, and he is the link between those persons and the family member of that person who has gotten bail. He takes his down payment, and then he goes before the clerk of the peace, and then some problem arises with the deed. That family member is not going to get back that deposit and has no recourse to go to the police or anyone else to try to get it back. So to the extent that the proposed bill seeks to create an avenue which can direct persons away from this system is commendable. There are, however, some of the clauses which I would want to make some suggestions. Cash bail, as it is, as my colleagues have stated, is nothing new in the system. I have never seen cash bail given as a first option or only option. It is, in my experience, only given in the alternative. So in other words, the tribunal says you are given bail in the amount of 100,000 surety. In the alternative, cash bail in the sum of X or Y. It's never given as a first option. When you look at the proposed bill, at clause 4A, it gives the four circumstances under which the forms the bail can now take. My concern is, and particularly my concern is for the magistrates who are creatures of statute. Looking at it in black and white, they may simply say, well, we can only really give one form. So it takes away from what presently obtains, in that some persons simply do not have valuable land security, and to that extent, the cash bail alternative is real. They can all pool their resources together, and in some measure of comfort, it really doesn't matter how the matter is determined. The money is safe. Whether the person is guilty, not guilty, once the matter is determined, their money is safe. So it's a sort of savings in a sense. But if in effect, the magistrate looking at this says, well, I could only really give you the cash bail, and they don't have the cash, but they have the land, then that option is taken away from them. So I'm wondering if, in those circumstances, and having regard to what presently obtains, if 4A can be worded in such a way, so this magistrate, this creature of statute, who really works within the parameters of what is written in black and white, can understand that they will have the option of maintaining their current practice of putting it in the alternative, where persons have the choice of one type of bail or another. Madam President, when I look at 4B, and it's not that the current legislation says any differently. It speaks about the defendant taking his own bail. The only circumstances I know of in which a defendant can take his own bail is when he is granted own bail. And that is usually for very trivial offenses. And the own bail really is that he signs as his own recognizance, and he doesn't part with any money. It's the only recognizance in the sum of 5,000 or 10,000. And if he doesn't show up, then he is called upon to say why that money should not be forfeited from him. But how it is worded here, Madam President, it would seem to suggest that he can provide valuable security by way of a deed. Now, that has never happened. It has never happened where, and certainly I know of no circumstance, where someone can present a deed with their name on it and stand security for themselves. Certainly, with respect to the money, because he's in custody, he would not be able to come out and get the manager's check in the first place. So that doesn't seem that it would be possible, although if he has a joint account, his liquid cash money can be used. So that in those circumstances, there is a concern that the practice as it is now is that if you have a deed and it bears the name of the accused person, it is not utilized at all. Because one of the functions of the bail is so that person, there's a third person who is now putting up valuable security to ensure the attendance of the accused person, who may very well have an interest not to come to court. So you have this other safety measure in that I am willing, and it shows the court, I am putting up my security because I have faith that this person will attend, and I will do all in my power to ensure that he attends. So it's certainly not the case at all that I know of that a person can ever use security in his own name by way of immovable property. So that seems to be something that needs to address. As I say, in the current legislation, I think it's also worded like that. But in actuality, that never, ever happens. I also see, Madam President, that when one looks at Clause 5, which seeks to amend Section 17, 5(2)(c), which states the following part: where the security has not been forfeited and the defendant is convicted, the court may, with the defendant's consent. Now, if it is the defendant, it's not the person who is putting up the security. It cannot be that the defendant is the one who's given the consent to part with security which is not his own. So I cannot see in any circumstance why the defendant, who would probably say, well, yes, go ahead and use it, should be the one and not the person in whose name the security is taken out. So, Madam President, I think that should change, and that should be amended to reflect, instead of the defendant, the person in whose name the security is taken out, bearing in mind, of course, that I'm saying I know of no circumstance, save and except where a person is given his own bail, where the defendant can stand security for himself. So it never happens, but yet we have it here, where the defendant must give consent. And then further down, at subsection 6, where the court makes an order under subsection 5, any remaining balance shall be refunded to the defendant. So the opportunity there is for the defendant to get refunded monies for which he has not put up. The practice, of course, is now that when the matter has been determined, the person who has taken out the bail goes to the clerk of the peace, presents the relevant documents, they verify it, and that person is the person who gets back the money. No one else can get back the money. So that too, in my respectful view, needs to be looked at. Now, Madam President, why I'd say it's commendable to create this other avenue, we still must be mindful. Now, I know, so for instance, in some instances, and I suppose this will be more function for the courts, that if a person is charged with certain types of offenses, the cash bail alternative, from the court's perspective, they are less amenable to it. And this is in terms of drug trafficking, in terms of money laundering. Because of the nature of the type of offenses, one can see why the court will be a little more hesitant to engage in this form of bail. Where the proposed bill could be a little more open to further options, and I've seen it done at the level of the High Court, is that
motion to do. Leader of Government Business.
Thank you, Madam President. Madam President, in accordance with Standing Order 14.5, I beg to move that the Senate continue to sit until the completion of the business at hand.
Honourable Senators, the question is that the Senate continue to sit until the completion of the business at hand. Those in favour say aye.
Aye.
Those against say no. The ayes have it. This Senate will continue to sit until the completion of the business at hand. Senator Heath, you can continue.
Much obliged, Madam President. Yes, Madam President. I was simply at the point where the bill could be a little more open to other options, whereby, for instance, persons can be examined by the tribunal, whether be it the magistrate or the judge. And upon the provision of a statutory declaration, which, for instance, would say that they're gainfully employed and that they own certain assets, bail could be granted with that person in a name surety in a sum which would exceed normally 100,000. The practice now is that you would get a named surety in circumstances where the person is more or less of a tender age. So a young adult, 18, 19, or a child under the age of 18, you would get a named surety who is usually the father, the mother, or the guardian of that child. I'm saying there are persons who are in a catchment whereby they may own property, but the property is encumbered by a mortgage. So they cannot use that. They may, however, be gainfully employed. They may have certain investments which are tied up on fixed deposits or certain other funds which they cannot readily access. But apart from all these are persons who should be able, upon proof of these things, should be able to be named sureties. And certainly, in my experience, the persons who abscond and don't come to court are very few. In my experience, I've never had a client who has absconded, never. And the simple reason is that unless you have the means to fly and disappear, which is expensive, and not be around your family and get the sustenance of your family, you're not going to go away. You're going to stay and try to fight your case. So that it is not that we have a problem where people are absconding left, right, and center. The problem is the access to bail. There are a number of persons who have served virtual sentences simply because they cannot access bail. And because we do not have a right to a speedy trial, they have not had their trial, and they find themselves languishing in prison. So, Madam President, I have touched on the areas in which I say that the movers should look at the particular clauses and address it. It's commendable. It's heading in the right direction of creating options for this access to bail, as we seek, as my colleague Senator Edwards said, to move away from this professional system, bailer system, which is illegal and which we all know exists, but nothing is being done. Much obliged.
Attorney General.
Thank you. Thank you, Madam President. Madam President, somebody used the expression a little while ago that today is the last day of school in the Senate, in that we are literally on the cusp of the mandatory recess that the new standing orders provide that both the House and the Senate must engage in. I wish to start off by thanking most sincerely all honourable senators for engaging in very useful and reflective deliberations on this bill. But permit me at this juncture to also express a profound gratitude on behalf of the government, and certainly for my own part especially, to honourable senators for consistently good debate on a number of bills that we've had and which we've wrestled with. And I wish to say that very pointedly, including the opposition. I think that there has been a very good effort on the part of honourable senators, and I wish to express my pride that we as a country can actually come together and do some very good work. I say so because, and forgive me for putting it this way, I sat in opposition for 5 years, did very much like some members of the opposition are doing right now, contributed significantly to work, and I don't think I ever once heard a compliment or a thank you. And I really do think that you can very often wish that you can do something differently, and very, very rarely do you get the opportunity to be on the other side and to say thanks, where perhaps you've not heard it yourself. But I wish to be very pointed and to express my gratitude for the collaborative work that the Senate has done in all of its deliberations. I say that as well because I think that there is nothing to stop us from still exercising our politics as robustly as we do. And I think that our country develops well from the multiple perspectives to be gained. Honourable members have noted, and last night, and I think it had to do a lot with the amount of work that we had done yesterday. Was it yesterday? Sorry, day before, Tuesday. It's always long days for me, Madam President. I sometimes forget if I'm in the House or Senate. Honourable senators commented on an apparent rush by the government. And I wish to put that into context. There is no rush by the government. We have been asked as a Senate to observe. We have been asked as a House to observe the standing orders. There are only so many sitting days that are permitted. Honourable senators asked that the Senate do not sit for very long hours. The government complied by making sure that we ended almost on all days as best as possible at an early enough period. And the recommendation was taken up and the government exercised that role because honourable senators committed that they were prepared to sit on more days than one if we took that approach. And so last night I have to say that I felt a little disappointed to hear people complain. Understandably so. I mean, it was a late position on Tuesday. But I want to remind that certainly in the 5 years that I sat in opposition, we worked for much longer days than we are now. And I certainly view this as a privilege to sit in the Houses of Parliament, and I know all members do. So I wish to just point out that we've done our very best to be measured. A lot of this work, including this bill, has been significantly delayed because the Law Association asked for an opportunity to give commentary on the legislation, notwithstanding the fact that we, for instance, on this bill, consulted with the Commissioner of Prisons 1, 2, 3, 4 times, the judiciary in writing and on several occasions, the Director of Public Prosecutions, July 2016, September 2016, December 2016, January 2017, January 2017. The Criminal Bar Association, I want to put on record, we wrote to them July 4th, 2016, September 27th, 2016, December 16th, 2016. The Law Association, we wrote July 4th, 2016, September 27th, 2016, January 4th, 2017, January 12th, 2017, February 8th, 2017. We met with members of the Criminal Bar and the Law Association on 3 occasions, including the President's in 2 successive terms. And we were insistent that we had given enough time for commentary. But most respectfully, Madam President, the work that we have before us is one upon which there must be consultation, but I cannot compel people to take the request for consultation seriously. And I've demonstrated by reading out the dates and events that we've not had a degree of reciprocity coming from other members of society. And one must recognize that the work that we are doing is serious work. I heard Senator Edwards say a little while ago, we need to do more, that we should not take the little approaches to the bail bill. We should do more. Much of this debate on this particular bill has circled and centered around the whole host of the criminal justice system and the ails in the prison system, etc. But I wish to point out, it was the government's insistence that honorable senators received the invitations to go to the prisons. Because we felt that it was very important for honorable members to see, smell, feel, understand what we know. Taste. I recall vividly the day when honorable senators came back to the Senate. Many of them couldn't go to eat because they said they had to wash from fingertip to elbow and head to behind head. Because they understood for the first time, and I can tell you that when I sat in opposition, I'm not aware in the 5 years that I was there that any member of the Senate ever went to the prison system. That's why we started our interrogation on the prisons first as the litmus test on the criminal justice system. That's why Trinidad and Tobago knows now. Snap, snap, snap. 2,220 prisoners on remand, 986 for murder, 71% granted bail but can't access bail. Trinidad and Tobago is now using the statistics that the government has put out into the open. $25,000 a head to maintain a prisoner. This didn't happen by magic. It happened so that we could expose the persons who are called upon to make the law to the conditions of law which we are considering. Now, most respectfully, we're amending the Bail Act. The Bail Act in 1994, which is the substantive law as it stands now, there were 12 amendments to the Bail Act. 12 amendments to the Bail Act. Act number 19 of 2005, Act number 32 of 2005, Act number 30 of 2006, Act number 10 of 2007, Act number 15 of 2007, Act number 25 of 2007, Act number 17 of 2008, Act number 9 of 2011, Act number 11 of 2011, Act number 12 of 2012, Act number 1 of 2014, Act number 7 of 2015. That's how many times the Parliament of the Republic of Trinidad and Tobago in both houses sat and debated the laws in relation to bail. You know what my own view is in relation to the Bail Act? It's in need of significant reform. Why have we not dealt with the significant reform? Because there's current litigation going on in relation to the Bail Act, which is yet to be resolved, and therefore it would be irresponsible of me to come with the amendments that I wish to bring immediately, because there's some resolution that is outstanding. And what has the government then said? The government has then said, let's take the definition of common sense, fix the bits that we can fix now, because no one piece of legislative approach is going to be the panacea to all of the ills. And let us put it to work, because it's a fact, as Senator Creese pointed out, that many of our persons who are incarcerated, as Senator Richards reflected upon it, if even for 3 hours, can have life-changing experiences. Senator Coppin gave a fantastic contribution today, because he put it in the context of the social construct of Trinidad and Tobago. There are 174,000 applicants on the HDC database. There are 250,000 families squatting in Trinidad and Tobago. That's half of the country applying for a home or land. Half of our country. The Bail Act, as it is constructed, has survived simply by way of judicial somersaults. What do I mean by that? This bill proposes to do only a few things. Clause number 1, long title. Clause number 2, commencement date. Clause number 3, interpretation. Clauses 4 and 5 seek to amend 2 sections of the law, 12 and 17. Clause 4, in amending section 12, treats with one aspect of bail, and clause 5, in amending section 17, treats with the forfeiture provisions. The Bail Act as it is constructed is rather simple. The Bail Act as it's constructed says in section 5, a court can grant bail. That's the first thing it does. Secondly, in section 5, you can grant bail, but you can't grant it for certain things. That's in the first schedule. Murder, treason, hijacking, and any other offense for which death is prescribed. That's what section 5 of the Bail Act says. Section 6 of the Bail Act says that these are the things which a court ought not to grant bail for. It's the conditions for refusing bail. That's what 6 deals with. 6.1, their definition, considerations, and 6.2 tells you the things which you should review and therefore refuse bail for. That's what 6 does. The opposite to section 6 is section 12. Section 12 of the Bail Act says these are the things which are to be considered as conditions for granting bail. Section 6 of the Bail Act talks about the concept of a surety. It's the first time you see the word surety. Section 12 of the Bail Act talks about security. It's the first time you see the word security mentioned. Section 17.3 and Section 19.1 and the form of recognizance, which is in the schedule, those are the 3 other areas of the law that talk about what a security may or may not be. You see, the law, the Bail Act, does not define what a security is in a positive sense in the parent law. Senator Coppin was right, nail on the head. The form says you can use movable or immovable security or valuable aspects. But there is no definition for security as it is used in the Bail Act. In Section 12, Section 17, and Section 19, there's no definition. And what has grown up in the law has been that magistrate to magistrate keep applying different standards. We heard it today. We heard honorable senators reflect upon their experiences in the court, Senator Solomon, for instance, where you get one magistrate doing one thing and another magistrate doing another thing. And the fact is that the preponderance of security has now been sought and grounded in immovable property, meaning land. The only place in the law, in the substantive sections, which talks about security, meaning what is now to be provided for bail conditions, is Section 12, which we are amending. Section 12.4 has become a clause which is used almost on every single occasion. Section 12.4 of the Parent Act is the clause which says if you think somebody is going to abscond from the jurisdiction, if they are a flight risk, ask for security. That's what 12.4 does. But every person who has practiced in the criminal courts, or even civil lawyers who have had clients who've passed through there, can tell you for sure that the courts now use this Section 12.4 flight risk, absconding risk, for almost every single matter. That's a fact. And what this law seeks to do by inserting a new 4A is very simple. We are seeking to put into an express statement of law that you can consider 4 kinds of security: cash, certified check, bond from a licensed institution, licensed under the FIA, or immovable security. From an interpretation perspective, it can include any one of the opportunities or a combination of them. so constructed because of A, the application of the Bail Act over the many years, and B, because of the conditionalities of Section 5 and Section 6 of the Bail Act, if you look at it as a whole. So I heard Senator Heath in the observation made that we may need to tighten up the approach to use multiple aspects to have the judicial discretion to allow what is, as you put it, in common law the case. But it really is a hybrid position because it's a blend between the common law and statute as has come to be applied. So 4A comes about. Let's put in these express forms of security. 4B, 4C, 4D, 4E. What do we do there? It's really quite simple. In clause 4, we have inserted a 4A. That's the type of security. We put the 4 types. 4B says, pay the prison officer so designated. Why did we put 4B? What is the rationale for 4B? Why do we say put the prisons officer? We heard Senator Choate on Tuesday. Number one, prisons officers receive money as it is. It's a fact. Senator Samuel did some good research. It is Regulation 127, where the steward receives the money. We seek in the parent law to put in a positive obligation that the Commissioner of Prisons must have a designated person in the parent law to receive the money. So we have a receiving officer in parent law and not in subsidiary legislation in Rule 127. That's why we're adding in a new 4B. 4C, where we add in the new 4C, we're saying that the prisons officer shall issue a receipt. Do we trust prisons officers? Do we not? We're making sure the receipt goes to the person who pays and also to the Commissioner of Prisons. So we're bifurcating the expression of a receipt. 4D, we're adding in that the Commissioner of Prisons shall keep a record. We don't want this thing not inside of the parent law. We put it in the parent law so that there is a positive obligation. 4E, we say the days and times. 4F, we say that the minister can amend the schedule which prescribes days and times. Why didn't we put Sunday? An honourable senator asked, Senator Crease I think it was, because the prisons officers effectively don't work on the Sunday administratively in that provision. And in our consultations with them, they had accepted out Sunday. However, because we intend, and I'm going to speak to prison reform in a little while, because we are intent on driving the prison reformation, we've put in the fact that the minister can amend those schedules by order. So we intend to go to Sundays, and we intend to deal with the hours of operation. So that's the whole of Clause 4. Clause 5. What does Clause 5 do? We're amending Section 17. Senator Ramlin raised a very interesting point, and I had to look at it in many different ways. So Section 17 deals with the forfeiture provisions of the law as it stands in the Bail Act, Chapter 460. We're keeping 17.1 exactly as it is. 17.1 says, where a person has given security in pursuance of 12.4, and note that, in pursuance of Section 12.4. So where security is given in pursuance of Section 12.4, Section 12.4 is the absconding risk, and the court is satisfied that he failed to surrender to custody, then, unless it appears that he had reasonable cause for his failure, the court may order the forfeiture of security. That's the existing law that stays as it is. We are proposing in Clause 5 to amend what is Section 2, subsection 2, 17.2. We're keeping the forfeiture, but we're adding in the event where the person has given their own cash, because we're now adding that position in. The court does have a discretion to do that. It may not have been utilized, where one secures one's own bail, etc. It's a quid pro quo. Yes, the court may have better persuasion when John Brown comes and says, well, look, I will encourage this boy to come to court or this lady to come to court, and I'm risking it, I'm putting my money where my mouth is, but it still is a technicality. What we do in 17, in the amendments that we ask the Honourable Senate to consider, is we take the position a little bit further. If I can find my bill. We take the position a little bit further, we're actually asking the Honourable Court to consider making sure that the new 4A and 4B apply. It seems that my bill has somehow managed to disappear. If I could just lift anyone's. Thank you. So we're asking for, in section 4, in clause 5, we're substituting the new section 17.2. We say that the court may order a forfeiture. And in subclause 2B, we're saying the defendant, where he has given his own security but failed to, we're asking him to show cause why. And there was an observation that 7 days may be short. We're prepared to look at that. The 7 days that we have referred to is after the order for forfeiture. But when we add in a new subclause 5, 6, and 7, I wish to point out, and this addresses a point raised by Senator Heath, we are not allowing for the provisions to apply to security given by a surety. In adding in the new subclause 5 and subclause 6, we are allowing for the case where security has not been forfeited and the defendant is convicted, the court may, with the defendant's consent. We are solely dealing with the provisions where the defendant has offered his own form of security. It is not the surety's security, because in that instance you would need to have the surety's consent for the forfeiture. So albeit that Senator Heath's experience was that there aren't many examples of that, the fact is that we're providing for it. Now let me speak to the recommendations which we have put for the Senate in the new 12, the amendments to section 12, which is in clause 4. We were talking about cash, we were talking about checks, we were talking about the bonds, and of course real property. And Senator Dottin was very passionate last night about why it is bonds shouldn't happen. A number of persons asked questions about bonds. Senator Mahabir asked the question about whether the concept of a bond by an institution so permitted under the FIA offended Section 18 of the Act. Section 18 of the Act provides it to be an offence if someone has offered an indemnity for the surety. And then Senator Mahabir went on to say, look, you're paying the bank for the thing, and therefore you're running afoul of Section 18. But most respectfully, that's not the case in law. The indemnity in Section 18, which is said to be an offence, if you've said to someone, I'll be your surety upon consideration and the understanding that if I lose my thing, you're going to indemnify me against the thing. That's a whole indemnity. The fact that there may be a banking product, and you know, jump high, jump low, we may criticize banks all we want. They provide a service in this country. There is a free market economy. The regulation and control of the banking sector is often driven by the market. But the point is that when a bank considers the issuance of a bond could never be within the terms of a full indemnity. That, look, if I lose my security, I have to pay me back everything. That would be an offence under law, and that therefore cannot be the case. Senator Mahabir asked of Senator Coppin a particular question relative to which institutions other than the HMB provide the bonds. To the best of my knowledge, the HMB is the sole institution that does so currently. However, I am absolutely aware that there is a discussion afoot right now as to the provision of bonds in certain circumstances. And why? Because we are coming to what Senator Heath recognized, which is that illegality of the professional bailers. And that is not something that we can continue to turn a blind eye to. And I must say to honorable senators, as passionate as we may be about the need for justice and to reform ourselves and our systems to achieve criminal justice, it cannot be confused with criminal justice reform. Because there comes some sort of point where we still have to hold on to idealism and drag our way out of the mire that we are in. How else do we develop? Do we wait till we get it all right? Let's go big, not small, as Senator Edwards says. Let's get the right product. In 2016, when we came to ask for the continuation of the Anti-Gang Act and the savings of the amendments to the Bail Act, when that didn't pass, what happened was the law cascaded right back to 1994. The law as it stands is the 1994 principally, with a few exceptions, as it relates to the appellate rights, etc., which were inserted in 6A and other provisions of the law. However, I can tell you that as a result of that cascade, the government went back to the drawing board, and most respectfully, an entire Bail Act is required. If you look to the prescriptions where you can't get bail for 3 strikes, the 3 strikes are counted in 10 years. You cannot get bail if you have had 3 convictions in 10 years. What does that really mean when you put it into effect? What is the sentence likely to be in a 10-year period? And how long does it take you to get a sentence? If the current preliminary inquiry route or criminal justice route is that you're waiting 6 and 7 years for any one trial, if you get the first conviction, and let's say it was 2 years, how long before you get the second conviction or the third conviction? Isn't it therefore a logical nonsense to suggest that the 3-strike rule has any persuasion behind it? Isn't the fetter against the judiciary granting bail in and of itself a challengeable position? You see, there's a lot more work that is not as easy as it sounds. And most respectfully, when I said to Senator Richards that we were looking at certain reforms, we are and have drafted. We are looking at in the sense of something to come, and we have drafted amendments to treat with corruption and wrongdoing across the protective services. But for the prisons officer who's wrong, it's not the Bail Act that we're going to amend to do that. It's going to be the Prisons Act that we do it, like the Police Service Act and regulations, like the TTDF Act, like the Immigration, like the Public Service regulations and rules. That's where we are amending the law, because we intend to ratchet it up. What do I mean by that? We intend to bring for consideration that if you interfere with a policeman or member of the protective services or someone in discharge of public function, and you do so maliciously, you do so wrongfully, you're going to have the book thrown at you. We must protect our officers. But we are balancing it off by saying if we catch you in corruption, crapo, smoke your pipe, we're throwing the book at you on that end. Now, I want to raise something. We are in an active, hands-on relationship with the Canadian government right now. Honourable members would have seen, in whatever capacity, whether as attorneys at law, social work, missionary work, honourable members would have seen the prisons of Trinidad and Tobago. And yes, the reason why I read the dicta from Madam Justice Carol Gobin in the Edgill case was because the similarity between conditions of slavery, indentureship, and the prison system is the same. How many of us know that the remand yard was built in 1950? I said it on purpose. Do you know what the purpose of the remand yard is, or was? It was a hangar for aircrafts. That's what it was built for. The remand yard, yes, has 12 people sleeping in a 6x9, razor blade, as it said, 4 bunks, no mattresses, no plumbing, muck. Senator Richards gave a very good and proper description. So what do? Coming into the prison system, having done the litmus test, the first thing I did was to say, we are going to sober up the prisons. Senator Ramdeen was so very right when he said, until prisons are truly prisons, meant to lock you in and deny you the privileges of the world, then we're really just wasting time. Let me give you an example of what we did when we went in to sober the prisons. When we went in 2015, and I went personally, it was to do a reconnaissance of what we're dealing with. No CCTVs. Let's start with the conditions for detention as described. Yes, I accept everything Senator Richards said. abhorrently inhumane. No plumbing facilities, no ventilation, no room, 45 minutes out of 24 hours. Mothers see their children 1 day a year under the prison's rules, 1 day a year under the prison's rules. We have no exercise yard, no place for reflection, etc., depending upon where you are. First thing that we did was to say, right, what is the reform that is required? The government of Canada is in partnership with Trinidad and Tobago. We have a team in Canada right now. We have earmarked the works to be done at Remand Yard, for instance, for the retrofitting of all of the cells, to put in plumbing, to create an environment where less people are in the physical area. That entire work is going to cost us roughly $50 million. We've taken the bill down from $2 billion to build a new jail, and we can possibly spend $50 million and remedy that situation with fencing, with areas of reflection, etc. And I want to prove how sincere we are. Senator Richards said that he was impressed with the exception that is YTC. That didn't happen by mistake. The Office of the Attorney General went to work with the ministry that is under the Office of the Prime Minister of Gender Affairs, the Children's Authority, and the Prison Service. And we created 36 new dormitories at YTC with proper conditions, not the best, but as best as we could get, and we're working our way out there. There was supposed to be construction of new dormitories and a new area for a YTC. By the way, YTC is now a child rehabilitation center under law, so designated by law. But it was supposed to be built for upward of $600 million. You know how much it cost us to do it just by hands-on management? $1 million TT dollars. So what Senator Richards reported to this parliament did not happen by mistake. It happened with direct supervision, and I can tell you I was personally involved at every inch of the development for $1 million TT dollars, which is why we are working our way back in the entire prison system. But what else happened? We put on the grabbers and jammers, which were in a box. And do you know what the numbers of calls intercepted are? Senator Dottin, through you, Madam Chair, Madam President, 2 million calls in a 2-month period. 2 million calls in a 2-month period. I went and personally engaged in witnessing after I had received a phone call from death row in the prisons on my cell phone, in my office as Attorney General. I received a call from death row telling me certain things. I relayed the information to certain authorities, and a raid was conducted. Listen to what was found. I'm giving you an example. So in the same pails, the pigtail buckets, the little black buckets, the slop with whatever was in it, the handheld scanners were used to check the buckets. Nothing found. People observed prisons officers using the scanners to check the buckets. They checked every cell. Nothing found. They used the handheld scanners. Nothing found. I then instructed, by way of a suggestion to the relevant authorities, I said, you know, we have full-body scanners in the prison. Perhaps it may be useful if you took the buckets and scanned them in the X-ray. And let's look at the picture of the buckets. There, underneath the false bottom of every bucket, here's what we found. On one pass-through, 28 cell phones, 12 chargers, 21 batteries, 5 memory cards, 15 SIM cards, 16 headsets, 8 razor blades, store-bought knives, digital scales, projectiles from ammunition, marijuana, cocaine, 77 cell phones, Wi-Fi hotspots, 23 memory cards, 44 SIM cards, 146 chargers, 102 batteries, 104 earpieces, 1,000 plus boxes of cigarettes, 98 smoking devices, lighters, 686 improvised weapons, shavers, cash, flat screen TV, bolted onto the wall of a cell. So, Is the government blind to what is going on in the prison system? No. How did it get in there? I have a fair idea. What are we doing about it? The reform that we're doing, the CCTVs that are installing as we speak, some of them have been installed already, are being fed into background areas which are being double supervised. And what is going on is the reform of the rules that I'm expressing right now. You see, I can't wait, most respectfully as an Attorney General, to get it all right on the first go. I've been operationalizing this, thank God for the help of the Minister of National Security, who's been leading the charge on a constant basis. But most respectfully, honorable senators, there is no one occasion where we can get all of it right. And what the government has done is to approach the Parliament on a consistent basis to say, let's inch our way forward, inch our way forward, inch our way forward. And I really do believe that we are on the right track as a country. And I'm only saying this because we have spent to date, from 2010 to 2017, we've spent $26.5 billion in the police service. We have spent $15.3 billion on the Trinidad and Tobago police service. It's clearly not a matter of money. That's plenty money. It has been a matter of will and common sense and inching your way out of the problem and being resistant to the blows, the licks. You have to do better. You have to come again. Let's go perfect. Nothing in this country passes on perfect basis. That's why we took the approach we did on several pieces of law which this honorable Senate has considered. Motor vehicles is one of them. We've been talking about reforming the motor vehicles in terms of red light and demerit points and technology and spot cameras for 26 years when the provision for regulations came about. So why should we give up the vision of dealing with professional bailers? Why should we give up the ability to provide new forms of security just because the banks are thieves, as some people say it? Really, as a concept of criminal justice reform, we have to look towards the positive. I read out the encounters with the prison service to tell you that it isn't that we are not aware and most anxiously aware of what's going on. Honorable senators will recall that I said that I would ensure that honorable senators were given the invitation to go and see the prisons. And that was a very purposeful decision on the government's part. Unless you've seen your prisons, your old age homes, and your depth of squalor and poverty in this country, we are living as somnambulists in La La Land. Wow. That's where we are. People get into their cars, they go to work, they can't remember the trip between leaving home and going to work. It's a blur. You socialize with the people that you know, but the ability to stretch oneself into the zone of real, effective, and meaningful change is really something that requires perspective. And most respectfully, some honorable senators said that we had not taken as aggressive an approach.
Madam President, on a point of clarification to the Attorney General, you mentioned that members of the Senate were invited to visit the prisons. I received no such invitation, and I'm wondering if it were the members of a particular committee.
Sure.
If you could clarify.
Yes, Senator Amin, you're correct. It was inferict to say all members of the Senate. It was via the respective committees where the government members had the ability to cause the invitations, etc. But it was done specifically because many people had not had the opportunity. I mean, the attorneys who practice would know these things, correct? So what I'm trying to demonstrate is this bill is part of a consideration which must be engaged in.
Well, you have 5 more minutes.
Thank you, Madam Chair. The consideration which we must treat with is the unregulated phenomenon of professional bailers who demand and receive exorbitant sums which are never checked. I wish to put on record that we specifically intend to put plastic into Operation Senator Crease. The Exchequer and Audit Act, in combination with the Exchequer and Audit Electronic Funds Transfer Regulations 2015, are already built out to allow us to put plastic into operation. In fact, the government is on an aggressive approach for the implementation of plastic across the system. And that's why we did the amendments to motor vehicles. Because the operationalization of electronic transfer of funds did not happen when it should have. The Electronic Transactions Act was passed in 2011. 2012, 13, 14, 15, nothing happened. It fell to us to operationalize the system. And I understand that certainly the intention to do it was there. I think that what happened was a lot of the public service issues came into the mix. There are two amendments which we've circulated, which we'll come to, one of which treats with Senator Ramdeen's observation of how we could probably improve Section 17, and we propose to actually remove the reference to 12.4 as a limitation so that we can apply certain of the provisions, and we've also sought to improve the time frames for consideration. But, honourable senators, if we limit ourselves to the material before us, I would be hard-pressed to understand why it could not be supported in a genuine, honest sense. Because this bill, as Senator Coppin put it, is not about a lot of things, but it is about something which is very important. Definition of types of security, dealing with the professional bailer issue, dealing with the access to bail, which 71% of remandees cannot access because of the circumstances they find themselves in. The rest of it is going to come by way of amendments which we are going to bring in the month of September onward to the bail legislation, because we intend to approach the Parliament in a combination of events, including a reflection upon anti-gang in a different form after having pulled some information which was requested. Madam President, I do hope that honourable members can lend support to this. The government is wide open to listening to views in the committee stage, and I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Amend the Bail Act, Chapter 460, be now read a second time. Those in favour say aye. Aye. Those against say no. The ayes have it.
The bill entitled An Act to Amend the Bail Act, Chapter 460.
Attorney General.
Madam President, in accordance with Standing Order 66-1, I beg to move that the bill be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that the bill be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye. Aye. Those against say no. The ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Is everyone in receipt of the proposed amendments?
Madam Chair, I understand that Senator Mahabir has circulated amendments, but I have not received any.
Could I, by a show of hands, see those who have not received the amendment proposed by Senator Mahabir?
I guess it was just me.
Attorney General.
That's
Attorney General.
Yes, ma'am. Yes, please.
Clause 1.
The question is that Clause 1 stand part of the bill. Honourable Senators, the question is that Clause 1 now stand part of the bill. Those in favour say aye.
Aye.
Those against say no. The ayes have it. Clause 1 now stands part of the bill.
Clause 2.
The question is that Clause 2 stand part of the bill. The question is that Clause 2 now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 2 now stands part of the bill.
Clause 3.
Honourable Senators, the question is that Clause 3 stand part of the bill. Honourable Senators, the question is that Clause 3 now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 3 now stands part of the bill.
Clause 4.
Honourable Senators, the question is that Clause 4 stand part of the bill. There is an amendment proposed by Senator Mahabir.
Yes.
Senator Mahabir.
Thank you very much, Madam President. Madam President, the amendment which was circulated refers to 4C, and that is the bond issued by a licensed financial institution. The Honourable Attorney General, in his summing up, did indicate that there is interest in this market for risk. And what my amendment does is recognizing that the financial institutions governed by the FIA are profit-making institutions. In order for them to participate in this new area of the economy effectively, I am recommending for consideration of the Honourable Attorney General that we recognize that a priori as opposed to post facto. And a priori, we recognize that there is, Madam President, going to be a cost attached to this particular type of financial instrument, and I am recommending setting the path now, given what has come out in the debate, that the problem has always been the cost the accused has ultimately had to pay the professional bailers. I think if we were to regularize as of now and regulate the financial institutions with the cost of their bonds, the cost of their particular instrument, not to exceed 10% of the face value of the bond, as is done certainly in the United States jurisdiction and in the Philippines, it will go some way, Honourable Attorney General, to starting the case where we would begin to recognize that in this industry there is going to be a business emerging, and we in the Parliament should start to regulate it now so that it is in the interest of the accused as opposed to the interest of the suppliers of these bonds. So I put this for your consideration. Thank you.
Madam Chair, it's an excellent submission. The difficulty that I have with it is that, most respectfully, I think that regulation of instruments really are dealt with in another piece of law. It is certainly open in terms of the supervisory functions of many other pieces of law, including the SEC, if it was determined to be that way, or the central bank, insofar as it has supervisory function under the FIA and under the regulatory environment that exists there, for that regulatory environment to happen there. If we left it that way, it certainly would be the position that we could test what the market actually produces and then work the market into what ought to be tolerated, lest this thing run afoul of sensibility or substitute one exploitation for another. So I understand the intention behind the amendment, but the flexibility really is found in other pieces of law that can deal with that, as opposed to this piece of law?
Through you again, Madam Chair. The concern I have, Honorable AG, is that I have looked at the Central Bank Act, which will regulate the commercial banks, and I have checked the Securities and Exchange Commission. I've checked the FIA as well, and nowhere did I see any provision being made for the regulation of this type of instrument with respect to the interest charge, which will be determined by the market, or with respect to what it will be charged by a third party. You see, AG, we don't have a secondaries market for bonds in Trinidad and Tobago. As is known, we only have one financial institution that currently sells bonds to the public. So what we are dealing with would be bonds which are issued by bona fide financial institutions. And I just want to put on the record that I have a concern that we are not protecting the public interest in this piece of law, that is the accused, unless we recognize that these financial institutions may engage in a practice that is going to be to adverse interest of the accused. And so I really would like for your office to monitor the situation so that if in fact it requires recommendation, we modify since we are dealing with bail, we would modify this instrument as a condition of bail so that we can put a charge on it which is reasonable.
We will certainly monitor, but I beg to differ. The legislation does permit for the assessment and approval of products, and it is in the approval product in particular that one has the ability in law to be circumscribed as it relates to this kind of positioning. So there is facility in the law, and we will certainly be monitoring it as this product potentially emerges. There may be no risk, no appetite for it, but it is certainly worth the while from this perspective. I should add that this recommendation came specifically from the judiciary, the concept of the bonding aspects.
Senator Ramdeen, you wish to say something on Senator Mahabeer's proposed amendment? Okay, well, let's just deal. Senator Mahabir, are you?
I've just put my position on the record, Madam Chair, and I am happy with the response of the Honourable Attorney General. So I will withdraw the amendment.
So we're still dealing with Clause 4. Senator Ramdeen, you wanted to raise an issue?
Thank you, Madam Chair. Madam Chair, Attorney General, through you, Madam Chair. When you look at the structure of Section 12, Attorney General, I had flagged that the giving of security under 4 and the giving of security under 4B are potentially two different, how I read it, was, under 4 would be for the persons who, if you want to use the word in inverted commas, have a risk of absconding.
Yes.
And then you have inserted 4B, which is to capture everyone else who may not have the risk of absconding. That is the way I read it. If you agree with me that that is the position, then when you come to Section 4C, and it is circumscribed to apply only to 4B, ought we not to also include the security given under 4 as well?
If I could just ask, Senator Ramdeen, we're on. Okay, I want to follow the argument carefully. With your permission.
Can I flesh it out like this?
Yes,
Do you have the Principal Act there?
Yes, I do. I have it right in front of me.
Good. So if we go to the Principal Act at page 12, which would be subsection 4 of Section 12.
Yes.
That says, where it appears that the applicant for bail is unlikely to remain in Trinidad and Tobago until the time appointed for him to surrender into custody, he may be required before being released on bail to give security for his surrender to custody, and the security may be given by him or on his behalf. Now, I consider that to be a separate section applying to persons who there is some evidence by virtue of the prosecution that will be brought to the attention of the court on the application for bail that they are unlikely, and that was what triggers that section to be applied. If that section is circumscribed to the circumstances as defined under that subsection, when you come to Section 4B in your at page 2 of your amendment to Section 12, your new Section 4B, that will catch everyone else who is not caught specifically by Section 4, so that there may be people who are applying for bail who the prosecution does not advance any evidence that they are unlikely to remain in Trinidad.
the purpose, as I understand it, of your 4B is to catch those persons who will not be caught by the original Section 12, subsection 4.
I catch your concern as arising under Section 17, not Section 12, where Section 17 makes the cross-reference back to Section 12(4).
But
4B, as we have it here, is solely for the ability to pay after the close of business. I'm looking at page 2, 4, big B, where bail is granted to a defendant and he is a person acting on his behalf. Is it that you're pointing out that where bail is granted in any circumstances which is beyond 12(4)?
Correct.
I see. So your point here now is where 4B applies to circumstances not limited to 12(4). So that's your point.
Yeah. So that my reading of your amendment is that one aspect of your 4B is to catch the payment, but the principle, if I can call it, the first part of the subsection is to actually catch all of those people who are not caught by 12(4) in the original legislation.
I understand,
So my point is, when you come down to Section 4C, which allows the prison officer.
I'm sorry. Senator Ramlin, I've caught you. If you just permit me a moment through you, Madam Chair. Madam Chair, Senator Ramlin, I'm thinking and aloud that perhaps the mischief or perhaps the policy of having it as broad and not circumscribed by 4, I think that your interpretation is perhaps one of the two interpretations, but a very strong one. I think you're right. It could help us if we were in 4A, 4 big A, to remove the generality, so to remove the specificity of subsection 4. So if we were to say the security, words to the effect that where security is ordered by the court to be provided, not only in 4. So we're removing subsection 4. It may be in the form of. And then where bail, and then 4B would follow, where bail is granted to a defendant and he or a person acting on his behalf is desirous, etc., it would then flow from there.
Well, it perhaps could be caught exactly in the way that you're suggesting. If we perhaps shy away from the words under Section 4 and simply say where something to the effect of where security is given pursuant to the grant of bail.
Yes, I think that captures it perfectly.
So that it will catch 4,
yes.
4A, whatever, and
yes.
then you deal with it there.
So, Milton. So, Madam Chair, instead of the words appearing in clause 4, described as 4 big A, we propose to delete the word V, and it would instead be where. And then after the word security, insert the word is. And then after the word given, we insert the words for the grant of bail, it. And then we delete the words under subsection 4. So the chapeau to 4A would read in full as follows. Where security is given for the grant of bail, comma, it may be in the form of, and then it continues. So I think the technical way to describe that is delete the chapeau in 4A and replace with those words.
Members, any other comments?
AG, sorry. In 4B now, I'm concerned. I have a concern that could perhaps be dealt with by the drafters. Is that we use the word in the 6th line. We say the close of business at the office of the court, and the only concern I wish to raise, AG, is that under the Principal Act, in the interpretation section, there's a definition of court as including a judge, a magistrate, a justice of the peace, or a coroner. And in the case of a specified court, includes a judge or a magistrate, or as the case may be, the justice having power to act in connection with proceedings before the court. I was wondering if the section would not be a tighter draft if you were to insert after the words court, the words granting bail, so that we take out all of those people that are included in the definition of court in the interpretation section itself. And we limit it only to the person who has granted bail, whether it be the High Court or because it can lead to confusion in a technical sense, because court is already defined under the Principal Act, and we're using that exact term here.
Yes.
So perhaps if we can include the word close of business at the office of the court granting bail, and you continue there on the day on which bail is granted.
I think that's a very good suggestion. You're right. I hadn't looked at it that way, that court, well, the definition of court was done to allow the court who was granting in the circumstances where JP is sitting.
I think we have to be
magistrates.
careful because it is actually defined under the Principal Act.
Yeah.
Senator Heath, you wanted to say something?
Yes, Madam President. It's with respect to 4E. I still have this concern about the present practice where persons are granted bail in the alternative. And certainly if the intention of the bill is to create a wider option, as does not currently exist in statute, I am afraid that magistrates reading the proposed bill, if it comes into law, will go by the strictures of what is written. I understand the Attorney General to be saying that common law would exist and there's the statute, but the statute would override the common law, it being codified, and the magistrate being a creature of statute. And where a magistrate believes that they can really only give one form mentioned under 4A, it will deprive persons of getting that alternative in circumstances where they don't know which one they would get to first. So they may be able to get the security by way of immovable property, or they may get the cash. And usually it's a toss-up to which one they get to first. So I'm afraid that the intent of the proposed bill will be defeated if, in fact, magistrates read this strictly, that they could just need to choose from one.
Madam Chair, may I? Thank you, Senator Heath. So, if I had understood the drafting as capable of allowing for the range of options to be applied because of the use of the disjunctive or, as it appears after 4AC. However, I hear you loud and clear that perhaps magistrates sometimes need, or judicial officers sometimes need, a little more clarity. So, please correct me if I'm wrong. What we're trying to catch now is the circumstance where alternatives may be utilized. Well, permutations, combinations, and/or alternatives may be utilized out of this array. Is that what we're trying to catch? Yes. Okay. And the suggestion is that we consider something which would, out of an abundance of caution, allow the judicial officer to know that there is that discretion. Okay.
respect of the same clause? In respect of the same clause 4?
Madam Chair, what we're wrestling with from the CPC's team is the fact that it's usual that we don't express what is already known, that the court has a discretion to exercise its discretion in any way. So the focus is upon the fact that the court may do something. The forms are expressed as that which is achievable, but that word saying that the court may do anything in its discretion is really what we're trying to catch in the alternatives. So the Senator Amra.
What about in the 4A, in that first line? What about if you add, it may be in the form of all or any of? I think that is what. So you may have a scenario where you have a combination of all.
On the grant of bail, not the form of the security. No, but this, what he's trying to do cannot be in these sections. It had to be on the grant of bail, that when they grant bail, it could be in the form of X or Y. This is dealing with.
Madam Chair, the advice from the CPC's department is that the clause as drafted with may and the disjunctive or is the correct terminology to express here, because when the bill is, if the bill becomes law and the law is read as a whole, when one looks to the conditionalities expressed in 12 as a whole against the prescriptions set out in 6.2 as a whole, and then the general practice of this, there is nothing to change the fact of how the court exercises its alternatives, because that has been left undisturbed. So if the fear is that the codification of an express statement of the types of security which may be acceptable to the court, then it is not going as far as saying how that security is to be applied. All that 4A is providing is what type of security a court may look at, not the permutation or combination of that security, so that the operation of 4A as it stands doesn't go as far as saying the methodology for applying it.
If I may, Madam Chair, I wanted to echo what Senator Choate had said on Tuesday, since she's not here. She had said that the clause 4 in the proposed amendment, 4A, is contradictory to what exists in Section 6 of the parent legislation, specifically 6.2a, and that's regarding reasons for not allowing a bail if someone is a potential flight risk. So what she had suggested is that we eliminate 4A and go straight to 4B and look at how we can reword it.
I listened to Senator Choate's contribution clearly. Mm-hmm. Her statement, as we recorded it as well, was that 12.4 collided with 6A, 6.2a. But that's why I was very careful to say what 6 does versus what 12 does. 6 is where you reject, and 12.4 is where you consider flight risk, the conditions. So there were two different aspects of it. So when you looked at the phrasing of the law, 6 versus 12, there was no collision. Now, of course, don't get me wrong, I thoroughly respect and accept the fact that Senator Choate has long past experience in these particular courts. But 4A, as it is here, does not collide with with 6A, 62A. 62A is where you can reject bail for that ground. 4A, as we're putting it, is saying what forms of security you can use, because security has never been defined in the Act. It's just to be interpreted.
Okay.
So I thought that she was making the general observation that the flight risk clause, which is 12.4, which we're not amending at all, may be viewed to collide with one of the reasons why you can reject. Maybe, and then she went on to say it's perhaps superfluous. But that has stood as the law and is practiced on it since 1994. So I didn't want to disturb that particular perspective. But 4A, as it stands in the bill, is only the forms of security. Prior to that, 4 only says where a court is giving security. It doesn't say what a security is. And then what happened is the practice went squarely to land, effectively.
But just to clarify, isn't the first sentence, the first line of 4A, about, let me find the exact wording, about where a person might be considered a flight risk? I'll find the wording.
Sorry, would you say that again?
Isn't section 4A introduced by the qualifier of where an accused might be considered a flight risk?
Okay. Sorry, so if we look to the Parent Act.
Not the parent,
4.
opposed.
I know. So, yeah. So 12.4 is the flight risk. The tie-in to the flight risking, we've just removed by deleting the reference to 4, to 12.4, consonant with Senator Ramdeen's recommendation that we think broader than just the flight risk clause. And so now we're outside of the flight risk clause.
Okay, thanks for clarifying.
Yeah, thank you very much, Madam Chair. And Madam Chair, I did concede to the Honorable AG with respect to the amendments I proposed on 4AC. But what I want to raise with respect to 4AC is this. Given what has occurred prior, you see what 4AC does is that it binds the magistrate to the following. A bond, one bond, issued by a financial institution. And I'm wondering whether in the spirit of the law, you would not want to amend it, Honorable AG, to say bonds issued by licensed financial institutions. Reason is, if you have a bail for 100,000...
I understand you. The drafting terminology in Thornton's is that the singular includes the plural, believe it or not.
Okay.
So it is squarely captured.
Okay, however, this is my concern. Does it mean that when you say a licensed financial institution, that someone who has a $60,000 bond from one institution and a $40,000 from another financial institution, that those two bonds can be pooled for a $100,000 bail, although they came from two different financial institutions?
Yes.
Very well. Thank you very much.
And, Madam Chair, if you'd permit me, in thinking aloud on the issue raised, it may be useful to meet Senator Heath's observation that we think about, and I would welcome through you any views on this, if we dealt with a qualifier to 4E, that's 4 big E, and if we said expressly, notwithstanding subsection 4E, a court may continue to grant such other forms of security as it thinks fit. That would put it in an express sense open, for instance, for chattels or other forms of security that are beyond that.
Well, it certainly would. It certainly would. But I don't know if the magistrate will be able to wrestle within 4A, those four types, forms of bail within themselves. So, for instance, and of course, the irony is we need to consider that even though the practice is, it is given in the alternative, I don't know that the magistrates are exercising that discretion properly now, in that the law as it is now, I don't know that they are following it properly. But that being the case, and looking at the intention of the bill, we certainly would want to maintain it, because it is a very viable way of getting persons out on bail sooner rather than later.
in addition to what Senator Heath has said?
Through you, Madam Chair, to the Attorney General. Perhaps to take away the fears of Senator Heath in terms of the very the point that he's making, perhaps it can be solved in a non-legislative way. If you, through your office to the Chief Justice, have indicated to the magistrates that this has been passed and this is the position in a non-legislative way, through some form of judicial education, it can be known to, or it can be made, the magistrates can be informed about the provisions of the Act, the way in which it is meant to be, and I can't see a judicial officer in the position of a magistrate not understanding that their discretion has now been changed by virtue of a piece of legislation, and they apply, they exercise their discretion accordingly.
I thank you, through you, Madam Chair. I've in fact invited the Chief Justice to put a general practice direction in relation to the granting of bail because it's chaotic. But I think that Senator Heath may have uncovered something which we can prescribe in another alternative way, and I invite this through you. It may very well be that we should add an E, a 4AE, such other form of security as may be acceptable to the court. Sure. That would take care of that form of security not expressed here. It would allow the law to continuously develop, and it could probably provide for the alternatives to be layered in that paragraph. So, Madam Chair, if we, at paragraph 4AC.
No, a new E?
Yes, Madam Chair. At clause 4, in what is described as 4 big A, capital A,
yes.
At paragraph C, we delete the word or. At paragraph D, we delete the full stop and put a semicolon and insert the word or. And then we insert a new E.
Which is
and we put the words such other security.
You're at form of security.
Form
of security.
Of security.
Form.
Such other forms of security, or we can even go as far as to say, or combinations thereof, or combinations thereof, as may be, as the court sees fit. So the E would read, Madam Chair, such other forms of security or combinations thereof as the court sees fit. Full stop.
Okay, members. Senator Ramdeen.
Yeah, AG, I just want to flag the point I think that was expressed by Senator Choate in a different way, which is if you look at the Principal Act, section.
Clause, if you could just.
I'm dealing with the same clause 4.
Yeah.
Okay.
If you look at the Principal Act, section 7 of the Principal Act, you will see that it provides, subject to subsection 3, where a defendant is granted bail, the conditions mentioned in subsection 3 to 6, which would include your 4
yes.
and all of your amendments of section 12, shall not be imposed unless it appears to the court that it is necessary to do so for the purpose of preventing the occurrence of any of the events referred to in section 6,
yes.
and B, to enable inquiries or a report to be made into the defendant's physical or mental condition.
Yes.
Now, that is going to provide a very serious hurdle as to how these amendments are going to operate, because I think the point that Senator Choate was making was that when you go back to section 3 to 6 cannot be applied, which would include your subsections that you propose to amend, unless it is necessary for the purpose of preventing the occurrence of any of the events referred to in subsection 6. Now, when you go to subsection 6 of the Principal Act, you will realize that A to G on page 7 are those circumstances where the court is prevented from granting bail because these are the situations in which the more serious considerations are to be made. Now, this affects the actual policy of what we are doing, because the conjoint effect of the amendment married with 7 and 6 would mean that what we are really doing, when you consider the way in which the Principal Act will operate with these amendments, is that we are actually going to be giving the persons who are the greatest risk under the Principal Act the ability to be granted bail by virtue of this section. And I'm not sure, it hasn't been fleshed out in the debate, and it's not the subject of any of the amendments. Now, I'm not sure as a matter of policy that is what we want to do. But I don't know if the drafters have considered it, but it can't be, or it strikes against common sense that 3 to 6 can't apply to everybody, because the Principal Act actually says that it doesn't. Because you have to impose on the Principal Act, which hasn't been amended, we're going to run into a real difficulty, because the preconditions of section 7A and B have to be satisfied before 4 could kick in at all.
I actually flagged and looked at 7 in its cross-reference to 3 to 6 as 4A to E was being added in. And when I went back to work out how much in need of reform this whole law is, and I looked to 6 being circumstances in which bail is to be denied in general provisions from A to G on subclause 2 of 6. Mm-hmm. Then I went to 12, skipping past 7 for a moment. Mm-hmm. I went to 12 and I looked at security in certain conditions, flight risking, and the fact that the court has, for some reason, been using this flight risking provision for everybody. So that seems to be the practice, whether right or wrong. I went back to 7, and I had to read it a good few times. So,
can I just agree with you and say that my problem when I read 7 the first time was to find out what is the event that you are trying to prevent under A.
Yeah.
Clearly, the event was not to be found under section 6.1. It had to be under section 6.2, subsection 2, which is why I went to A to G.
Yes.
Now, well, that's how I understood it.
Yes.
Now, in order for this thing to work the way in which we want it to work, we have to make some amendment to section 7. We have to. Otherwise, it just will not work. Because when you read the legislation, you don't get to our amendment, which is in 12.4.
We can actually treat with it if shall was me in the chapeau of 7.1. Not necessarily as put that way, but I'm just talking now to the conditionality as opposed to the express objection. So subject to subsection 3, where the defendant is granted bail, you're granted bail. The conditions mentioned in subsections 3 to 6 of 12 shall not be imposed unless it appears to the court that it is necessary to do so, A, for the purposes of preventing the occurrence of any of the events, B, to enable inquiries or a report to be made into the defendant's physical or mental condition. It could have been qualified by insertion or any other circumstance which the court considered fit. And that could probably do it.
I don't, perhaps that might be the cleaner cut, but I don't suggest that we just simply substitute shall for may. The reason why I'm saying that is because the way in which the clause is drafted in the Principal Act, it is followed subsequently by an exercise of discretion by the court. So it's not a simply cut off shall or may. It's shall. If you, let's say for example, you impose may instead of shall, it would then read in subsection 3 to 6 of section 12, may not be imposed unless it appears to the court that it is necessary to do so. It just doesn't fit with the exercise of the discretion in the later part of the section, because the shall is really what triggers off the exercise of discretion.
The problem that I'm having is that, and I mean this now insofar as there's a general review of the Bail Act going on, the entire Bail Act reads wrong.
No, but AG, I understand that, I understand that. I'm just I'm very firm in my view on this because we are actually amending Section 4, which there is a precondition for that section to even be activated by virtue of Section 7.1, so that all that we are doing here may amount to a very little assistance to anyone unless you can satisfy, because let's go back to the position. The judicial officer exercising the discretion is going to look at it and say, well, 4 doesn't apply because Section 7 makes 3 to 6 conditional upon A and B.
And then would have to work his way into seeing how it is 7 did apply, exceptionally 7.1a, for instance, for the purposes of preventing. You see, as I read it, and as I know from the application of 12 is the general principles for general provisions relating to bail. And these have been consistently applied, including surrendering passport, etc., which is the same thing that's not generally supposed to be applied. So 7 puts that filtration test, but it's almost always the case that surrender of passport, inform the court of need to leave Kate, all of these things usually happen. So I didn't see the amendment as being problematic in the way that the system is actually applied right now, because somehow I think that the system is applied beyond the text of the law as it is.
Well, AG, respectfully, through you, Madam Chair, sorry. We can't really legislate if we know the system is operating in a way it ought not to operate and base the legislation.
Well, that's in part. I think that what happens is that they allow it to operate by the application of 7.1e. That's not to say that I'm not open to improving out of caution the need for a consequential amendment to Section 7 as a result of having now further amended Section 4, because we've removed the reference to the absconding person's position to allow for 4B and others to apply. So I can see the merit in touching it right now. They're one of 2 potential options, and I would welcome through the chair views on this. If the construct of 7 is set shall with exceptions, well, then it's discretionary. This option A in 7.1a is you shall not do something unless it appears A for the purpose of preventing the occurrence of 6, and that I read 2, as do you, that's 6.2, A to G. To enable inquiries or a report to be made into the defendant's physical or mental condition, and potentially we can add in the catch-all or for any other, to allow for the court's discretion, a formula of words to allow for the court's discretion. It should allow us sufficient room for the provisions of 3 to 6 to apply, which are the general conditions of bail. Because Clause 7 says the general conditions of bail should not apply unless A and B. That's as I read 7.
Well, I don't think I read it like that, because in terms of the way in which 12 is structured, my suggestion is that we take out, for what you're proposing to work, is that we take out 7.1 altogether. Because the way in which the discretion under 12 is circumscribed by 7, it makes it very, very unworkable, even if you try to insert a new C. Now, 3 can stand on its own. That is just the simple discretion of the magistrate under 66A. But unless your drafters have some reason as to why we should keep 7.1, having regard to the purpose. You see, AG, I think the point that Senator Choate was making, and I didn't hear it myself, but listening to what was suggested, the Bail Act is structured in a particular way that you apply a more rigorous conditionality test, which is 3 to 6, where there are persons who are a flight risk. When I say flight risk, perhaps I should put it in this way, who there's a greater risk will not appear in court to secure their attendance. And that is why the Act is structured in such a way that 3 to 6 is specifically put in there for the purposes of preventing the occurrence of any of the events referred to in Section 6. Now, the clash that I think is being spoken about is the fact that what we are doing cannot be triggered or will only affect persons who are the more likely people to not appear, to take their trial or to appear there.
I don't read it that way. And,
Well,
I'll explain why.
Sure.
So, 7 says, subject to subsection 3, which is the exception to the Summary Court
Yes, so
Act.
that doesn't apply.
Right, so that's out. Where defendant is granted bail, the conditions in 3 to 6 of 12 shall not be imposed.
Right. So can we say that's a general position?
Right. So let me just work my way through that now. So subsection 3 of 12, providing your passport, information you want to leave the state, etc. 4, that's the flight risk person. 4A to E would now be provision of forms of security.
No problem.
No problem, which is the part that we're amending. 5, parent or guardian or child consents to be surety. 6, court has granted bail. It may on application, etc. It may on application by or on behalf of the person to whom it was granted or prosecutor vary conditions of bail. So 7 is saying don't have surrender of passport, flight risking, issues to deal with parent or child, and variation of bail unless you want to secure A to G of 6.
You want to prevent.
Unless you want to prevent. Well, you want to secure risk is what the way I was going to say.
Correct, yeah.
Unless you want to prevent or secure risk against 6 to A to G.
Right.
And I think that that captures literally everything. So it means that it can be applied on every occasion. Because I view a court as always going through 6 to A to G every time it considers a bail application. So that 7 allows for the application of 3 to 6 on every occasion. And insofar as 4B in particular, 4A as we're amending, 4A to 4E is simply form of payment, which certainly can't be something which is accepted out, and certainly the other forms of prisons officer receiving, etc., etc. Is your fear that we're making, that we should accept out the amendments 4A to 4E from this?
Let me tell you what my fear is. You have a first-time offender who comes before the court without any criminal record, without any fear of a flight risk. They come before the court and they make an application for bail. That person cannot be subject to the conditions that are set out in Section 7 of the principal law, which would be that 3 to 6 can't apply to that person. So you may be looking at it from the position of denying bail. Think about the person who comes before the court with no criminal conviction, nothing against him that is against the grant of bail. Now the person has to apply for bail still, even though they have a clean record. When they apply for bail and the magistrate is considering it, the magistrate will be wrong to go to Section 6. So that if the magistrate is going to be wrong to say that 3 to 6 applies to you in relation to 12, and there is no fear of the occurrences in 6 taking place A to G, then that person will not be able to benefit from what we're doing here. Because in those circumstances, 3 to 6 of 12 will not apply. So it will actually deny bail to somebody. It's a really crazy interpretation because, you know, the upshot to all of this is this. The people who we should be actually trying to benefit from the legislation are more likely to be the people who are not likely to benefit if the law is applied properly.
But I don't respectfully see that a magistrate could ever escape the considerations on a first-time offender or any offender.
No, but AG, the
for
point,
6-2.
no, AG, the point is this.
Senator Ramdeen and Attorney General, could I just intervene here, please? We've been going at it.
But it's an important point.
It is an important point, but we're also dealing with a clause that is not covered by the bill.
It is impliedly covered, Madam Chair.
I understand that. What I'm trying to say is that if there's to be an amendment of Clause 7 of Section 7 of the Act, it will have to be incorporated as a new clause.
No, Madam Chair.
Yes, just one sec, Attorney General, because it will be a new clause, because you're now going to be treating with a section of the Act that is not covered by the bill.
No, Madam Chair.
Well, okay, but even so, we need to get some, it can't be this to-in and fro-in between the Attorney General and Senator Ramdeen.
I don't think it's a to and fro.
We need to move on and deal with, Senator Ramdeen has raised what the Attorney General considers to be a viable point. I am not saying no to that, but I'm saying we've already proposed some amendments to 4A. We've proposed some amendments to 4B. Can I just deal with the paragraphs of this particular clause, and then we will deal with what Senator Ramdeen has raised? I think that is using the time more efficiently in the committee. Okay, members? So, Attorney General, Honorable Attorney General, we've dealt with 4A so far. We've dealt with 4B. Could we just look at 4C and determine whether there are any proposed amendments from the floor? Any comments?
Madam Chair, through you, Attorney General, because of the consequential amendment that we've made to Section 4A, I think 4B will have to come out of 4C, because it'll just be Section 4. I don't think you'll be limiting the discretion under 4C. I don't know how you see it.
Where a prison officer receives security in the form of cash or by way of certified check under Section 4.
It may be A or B.
This is in reference to the prison officer issuance of a receipt.
Yeah, but I'm just on the position of where we've identified under which subsection, because is he not going to also be able to receive cash under 4A?
Well, 4B is where he receives anything at all because the court was closed. And 4C is the provision of a receipt where he has received anything in 4B. So I think that the reference is correct.
As you please.
4D. For E, 4F, 4F, Senator Mark? No. You wanted to say something about 4F? We're on page 3. Okay.
Madam Chair, I'd just like to, so that you can move to put it to the vote, I'd just like to put on record the following. I appreciate and understand the observations which Senator Ramdeen is asking us to be cautious about. I'm going to give an undertaking to look at this thing very, very carefully. We may have to go back to, we have to go back to House in any event. And between the trip between now and the House amendments, I'm going to speak positively to the issue with the relevant stakeholders, and that if necessary to come back and look at it. I was wrestling with trying to understand the view expressed by my learned colleague. I don't quite share the same view, but I appreciate the need for caution, and I thank the Honourable Senator for that. So I give the undertaking to look at it carefully and to speak to it specifically, and I thank the Honourable Senator for raising it.
So, Honourable Senators, I will now put the question of the amendments to Clause 4 to the vote. The question is that Clause 4 be amended as follows. At 4A, to delete the words from the to of, and replace it with the following words. Where security is given for the grant of bail, it may be in the form of. And then after C, to delete the word or, and then after the word, in D, after the word property, to include the words or, and then there's an E, such other forms of security or combinations thereof as the court sees fit. And then in 4B, in the 6th line after the word court, inserting of the words granting bail. Yes? So those in favor say aye. Aye. Those against say no. The ayes have it. The question therefore is that clause 4 as amended stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 4 as amended now stands part of the bill.
Clause 5.
The question is that clause 5 stand part of the bill. Attorney General, you have circulated a proposed amendment.
Yes, Madam Chair. Thank you. Madam Chair, we propose, arising out of observations in the debate, that we amend clause 5 by firstly inserting a new subclause and then consequentially renumbering them and then treating with the time frame. If I could explain, we accept the observation that the law should apply to the generally wider ambit now prescribed for the various forms of security, and that therefore when we look to the parent law, section 17(1), which specifically dealt with security in the limited context of section 12(4), which was the absconding clause, that should be deleted, so that section 17(1), as it stands in the law, with the deletion of the words in pursuance of section 12(4), would read this way, and this is for the benefit of understanding of honourable members. Where a person has given security and the court is satisfied that he failed to surrender to custody, then, unless it appears that he had reasonable cause for his failure, the court may order the forfeiture of the security. So we propose in this circulated amendment to insert that deletion of words so that the clause will read as I have just read. So we're removing the limited circumstance of 12(4). Honourable senators also, several senators made the observation that the subclause 5A 2B, which read, where the defendant gave his own security but failed to surrender to custody, allow the defendant on application made within 7 days of making of the order for forfeiture to show cause why the forfeited security or part thereof should be returned. That 7 days was an unduly narrow window, and so we propose instead to delete the word 7 and to insert instead 28, so that we have 28 days from the making of the order of for forfeiture, bearing in mind that the defendant would have been in court himself on some occasions, but of course may not have been, so it at least allows some room for that process to happen. And those would be the amendments that we propose to clause 5, Madam Chair.
Senator Ramdeen.
Attorney General, is there any specific reason as to why we are extracting out the entire part of 12(4), which I suggested, and we're not just simply taking out the 4, and because the security is going to be given under section 12 in any event, whether it be 12A or 12B?
We could do that. I was thinking of the wider circumstance where security may have been given in general. Because 12 really was in reference to general conditions of bail, and insofar as a court may have given it generally in circumstances that Senator Heath was describing.
Well, remember, we're fixing that.
Yeah.
Because you've added your new...
The catch-all
in E.
I think that
so
it could work either way. I mean, we could keep the 12
and take out the 4.
And take off the subclause 4.
So that it applies to everything in 12.
Yeah. In which case, Madam Chair, we would be amending the draft circulated, that is the amendment circulated under my name. On the page, instead of in A, in subsection 1 by deleting the words in pursuance of section 12. We'd be deleting the words in pursuance of section, and then we would leave 12 and we delete the sub 4 so that the amendment to be circulated would read instead, in subsection 1 by deleting the word, open brackets, 12.
No, 4.
By deleting the word 12.4 and inserting 12. I think that's the way the drafters do it. You delete the whole thing, right? 12.4 and then substitute with 12?
Yes.
You're right. So sorry. By deleting the word 12.4. Right. So by deleting the words section 12.4 and substituting the words section 12. So it would read, in subsection 1, by deleting the words, open quotations, section 12.4, close quotations, and substituting the words, open quotations, section 12, close quotations, full stop.
Madam Chair, with respect to B, I know I had alluded to it in my contribution. I cannot think of a situation where the defendant can give his own security if he's in custody. Now, the only circumstances in which he can stand security for himself presently is by signing his recognizance, own bail, in the amount of money which is not really given. If the security to be forfeited here is the cash, whether liquid cash under 10,000, well, I can't see it being a certified check because he's in custody. What will inevitably happen is it will be his family, friends, or other persons who will be putting in this security, whether in his name or not.
But Senator Heath, he's not in custody. B is where the defendant gave his own security, but failed to surrender to custody. So it's where he had his own bail, the recognizance, there may have been a cash sum actually put into place.
But if I may, Attorney General.
Sure.
That cash sum is put into place because he is charged and he is in custody. Bail can arise in two circumstances. One can get what we refer to as station bail at the station, in which case, I don't know if this would kick in because you'd have to call out a JP, and technically it can, or at the court. But he has to be charged and he has to be in custody. So I don't envision a circumstance how he can arrange to have this cash. There might be the off chance where he might actually have the cash on him and ask for personnel from the court to facilitate the payment of the bail. But that would be the exception rather than the norm. So if it is that he is in custody and he has to provide the security, it would seem more likely than not the security would be provided someone other than himself. So what normally obtains, anytime the defendant does not turn up, the person who is the named surety is summoned to show cause why the money should not be forfeited. It's sent to them. So I see no harm in that practice being maintained. If on the off chance it's in his name and he's the surety, but I say, as I say, and my caveat is I can see no circumstance a person in custody getting that cash or that certified check to arrange his own. And bear in mind, I have never seen it where, certainly if it's security of the immovable type, where the person, the defendant's own name, he has his deed. The court never accepts that. So what I fear, when you later on you come to the defendant giving his consent to this money to be paid if he's convicted, inevitably what you're going to happen is mommy or daddy's money, who had initially paid it. but somehow registered in his name, and he's going to say, yes, go ahead and use it. And what you find is the family member is going to lose their money. That was never their intention.
I thank you, Honorable Senator. I read it as one of those possibilities, yes, but I read it as certainly many other possibilities too. So the express language of it is where the defendant gave his own security. If he gave his own security and it was his parents' money, etc., it's still in his name. It would have been liable to forfeiture anyway. But where the defendant gave his own security but failed to surrender to custody, I can't see that there isn't going to be a case where he could have been out for some other matter, his bail revoked, or his bail, or he having a bail aspect, whilst out on bail, is required to surrender. That it'll always be the case that he was in custody. See, I accept your example being one where it's being posted for the first time and he may have cash on him. But what about the situation where the bail is existing and he's out and he's required to surrender? That's the circumstance of 2B that we're describing here. And we have to provide for that circumstance where he has provided his own bail, particularly if it is in the circumstance of a bond.
Just to answer Senator Heath's question. He goes into prison. He's beaten. He sues his state. He wins. The check comes in the attorney's name. He then makes the check payable to a family relative. The relative puts it in his account. He then gets a power of attorney, gives it to the relative, and the relative takes out the security and carries it to the prison. It's his money. It will be his own security. So it might be the very unlikely circumstance. But once he has the ability to give a power of attorney to anyone to access his own funds outside of the confines of a prison, he will be able to get someone to act on his behalf, to get the security. He may come into access to funds while he's incarcerated, and he can post his own bond. Once the court, and I understand Senator Heath's point, I'm just trying to tell you of the circumstances in which it can happen. Mm-hmm. His point is that it is most unlikely, or probably never happens, that the court will give you the opportunity to stand your own bail. But the point about it is, under this piece of legislation, because of the amendment that we have made, which is in any other form, the court has that wide discretion to allow you to do that. And if you have funds outside, you just give a power of attorney to someone, they will go and access the funds, they will bring it to the prison, it will be part of your property, and then you can do it. In many cases that I do that, that's what happens. Or sometimes the prisoner will tell you, access the funds and bring it in cash, and they'll put it in their property in the prison itself, and they can do whatever they want with it.
Senator Mahabir wanted to raise an issue.
Yeah, thank you very much, Madam President. Madam President, I understand the point raised by Senator Heath. It was also raised by Senator Choate. I did not raise it because I had other things to raise, but I'm simply wondering, Mr. Honorable Attorney General, whether if you were to replace the word defendant with bailer, and the defendant is his own bailer, and we are looking at other bailers, what you are doing is that you are getting the bailer, and it may be the defendant has his own bailer, to seek to have a portion of the bail released.
That's in the existing law, which we're not disturbing. So
right.
That circumstance is in 17(1), which we have not amended.
Right. But I also want to come in to point number 6, where you had mentioned a 28-day period before. And I'm simply wondering whether under 6, you are not going to put a point raised by my colleague, Senator Creese, that the remaining balance shall be refunded to the defendant within a 28-day period. So you have consistency within the law on the use of a 28-day period which is a reasonable period to refund any balance, and you start to impose discipline on court procedures and practices.
Well, it's immediately refundable.
But it's not saying that here. And I think if it is implicit and the court is tardy, then I think we are saying, well, it should take no more than the 28-day period that you put in another section of the law. 28 days seems to be the maximum amount of time it should take the court to process whatever check and so on. Because immediate means the second, right?
I wish it worked that way, Senator Mahabir.
Let's hope it can work that way. You see, if you are saying, AG, that it is immediately refundable, and we know it is not.
As a concept.
Right, it's a concept. But the reality is it is not. you have indicated that a 28-day period for another section of the law is, in fact, reasonable. I would think that to grant a refund should all a 28-day period, which is 20 working days, should also start to impose upon the court discipline. That it may be small, but I think it would start them in the correct way, and it will satisfy the concern of me, Senator Crease, that refunds are going to be made in a timely manner.
I wish that I had the authority and liberty to agree to that now, but quite frankly, I accept the point that you're trying to guard against and to ensure is treated right, which is that there is some degree of balancing of the powers. I mean, far be it that one could balance powers where the state has by far a larger weaponry than the individual. But if we were to say where the court makes an order under subsection 5, any remaining balance shall be refunded to the defendant within 1 day, 28 days, whatever days it shall be. I don't know what happens next. I mean, even prescribing the time frame. My point is, saying that it shall be done within 28 days is in fact 28 days later than it's actually done, because once the court makes the order, it has to be done. So if I put 28 days or immediate, it still stands. Your question is, how does the man get the money back now? Where's the fairness to him receiving his thing? And regrettably, nothing is going to solve that, because sometimes people still have to go and move a court to say, well, I want back my thing, my property, my etc. And then there's an inconvenience and process that they go through. But right now, as it stands, why I said it was immediate is that the minute the order is made, it's payable. So it doesn't take me anywhere to say, put 28 days. It gives the court 28 days extra.
Yes, it is honorable, through you, Madam Chair, it is payable, but when is it paid? You see, I'm looking at the public interest here. We don't know when it is actually paid.
What I'm trying to prove in the point that I'm making is that if I put 28 days, I'm delaying it by 28 days. Once the court makes the order, unless the court fetters or stays the order by saying, well, this shall happen in 90 days or 28 days or whatever, it's due and payable immediately. So to say that it should be payable within 28 days is to give them 29 days extra. It's immediate. Whether they get it or not, I accept your point, is a process in and of itself which sometimes results in abuse. But that prescription of 28 days won't solve that.
Would a penalty such as the 5% that we pass in this parliament on judgment debts?
I hear you on banks, I hear you on regulation, I hear you on state. As Attorney General, I sit and I calculate the interest running on damages that the state should pay, and I'm astounded. There was a $10 million order made by the court in respect of something that I have found that was not paid, and the interest on it is $30 million. So the best investment in Trinidad and Tobago is to have a debt by the state. Not now. I amended it specifically to drop the rates.
Senator Mark?
Yeah, Madam Chair, before you put the question, I just wanted to draw to the Attorney General's attention. When you look at 4C, Attorney General, through you, Madam Chair, we are seeing where the Commissioner of Prisons shall cause the cash or certified check to be deposited at the next working day at the court. However, Attorney General, Prison Regulations 127 makes it very clear that the prison officer who receives monies for fines and other work orders, prison property, shall see that the same money are promptly brought to the account and paid into the treasury. Now, I was wondering whether we are going to have a bureaucratic nightmare here, or whether under the Comptroller of Accounts manual, they define what a receiver of revenue is and what the functions of that receiver of revenue is. And if I am reading the legislation carefully, the Commissioner of Prisons or his designate would be receivers of revenues, even though it comes in the form of cash for bail or checks or even bonds. So I'm asking, Madam Chair, whether, for instance, that should go to the Treasury, and if that is so, whether there is need for an amendment. I'm just asking.
Madam Chair, I can hopefully easily answer this. Senator Mark was referring to Clause 4, which we've passed, but he's raising it, and I understand the point. First of all, we're creating the obligation, we're creating the opportunity that the person can pay it at the prison before you'd have to wait until the court is reopened again. So this money that is being paid at the prison is always the court's money, not the Treasury's money for other property, fines, etc., that is actually going on, where prisons officers under 127 receive money and put it to the Treasury. So because this money is money which is for bail and must go to the court which was dealing with bail, we have to return the obligation to put it to the court. So there's a distinction between the two. Okay?
So, Honourable Senators, I will now put the question on Clause 5. The question is that Clause 5 be amended as circulated and further amended as follows. At A, by deleting the words Section 12(4) and substituting the words Section 12.
So the circulated is
BA.
in
Yeah.
BA. Would you repeat, please, Madam Chair?
By deleting the words Section 12(4) and substituting the words Section 12.
Yes, ma'am.
Yeah? Those in favor say aye.
Aye.
Those against say no. The ayes have it. The question, therefore, is that Clause 5, as amended, now stand part of the bill. Those in favor say aye.
Aye.
Those against say no. Clause 5, as amended, now stands part of the bill.
Clause 6.
The question is that Clause 6 stand part of the bill.
The Attorney General, did I hear you properly when you said earlier that you may have to consider including Sunday at some time in the future?
Yes, we're working our way towards that because we intend to fully operationalize payment by credit card, cash, or other, by plastic, as Senator Crease had put it. Plasticizing, I think that was the phrase.
Yeah. I was just, Madam Chair, I was just asking, Madam Chair, if you will allow, it is, I'm making reference to this Section 6, but I'm also referring to an earlier provision. I was just wondering, Madam Chair, and to the AG, the Minister may by order amend the fourth schedule. In the Prisons Act, is it subject to any kind of supervision by the Parliament?
I'm sorry, I'm not following. The Minister's amending of the schedule here?
The Minister.
Yes.
Ability to make order or to amend the order. Is that subject to a negative resolution, or is that just given?
You're asking whether under the Prisons Act
that
the line minister, which is the Minister of National Security, or to whom responsibility prisons falls, whether the law there provides for amendment pursuant to negative or affirmative.
Yes.
I couldn't say offhand. I'm almost confident it's negative because it would have been old law, and all old law was negative.
So that is why I was asking, Madam Chair, whether.
But this schedule here, this act is amended by inserting this fourth schedule. So we're amending the Bail Act by inserting, after Schedule 3, a new schedule, which is Schedule 4. And we're saying that in the Bail Act, that the minister can amend this fourth schedule by way of an order.
Just an order.
Yes, because it's only going to speak to the date and time.
Honourable Senators, the question is that Clause 6 now stand part of the bill. Those in favour say aye.
Aye.
Those against say no. The ayes have it. Clause 6 now stands part of the bill. Senator Mark, you wanted to raise an issue that may possibly be a new clause?
Yes, for the consideration of the Honourable Attorney General. Honourable Attorney General, I know that we have been grappling with the overcrowding. We have been speaking about those persons who are there and have been granted bail and they do not have the wherewithal. Even with what you have proposed, they would be hard-pressed unless they get very powerful forces to assist them. I would like to suggest for your consideration where a person may be charged with a summary offense, right? And that offense is punishable by maybe imprisonment for less than 2 years, that the court should grant that person bail on his own merit, character, reconnaissance. I'm saying that we have petty crime. You have somebody obscene language, traffic offenses, and that sort of thing. So I'm wondering, in trying to revolutionize how we do business, given, for instance, what could take place in the future, and rather than us having this continuous piling up of individuals, there could be instances of cases of a summary nature, soft, petty, that can allow an individual and the court to allow that individual to be granted his own bail on his own reconnaissance, as I said.
Madam Chair? May I? Yes. I thank the Honourable Senator for a very good submission. I can say that we're doing a number of things to try to achieve the management of this issue. The team, the CPC's team here, actually the head of the CPC's team, has the daunting task of revising our fixed penalties and our move to decriminalize those things which can be treated with by way of fines, etc. Many people have referred to the famous obscene language. Senator Mahabir has referred to that on umpteen occasions. That's one. Two, we're actually in active work with the judiciary for practice directions on how the judiciary ought to treat with certain matters, which is why we've gone into what the cost of maintaining prisoners are over time, etc. So we're, in addition to that, I should remind, there are the alternate forms of sentencing and resolution, particularly for juveniles, where that is now a very large part of what we're doing. And on Monday, the 10th of July, that'll be further discussed. So we are certainly looking at it. I think it's a move in the right direction, and we can perhaps report on that during the course of the next session of the Parliament, because we have done a significant amount of work on it and should be able to show the work product for consideration.
And Madam Chair, finally, would you want to consider, given the culture of violence in our country and the deterioration that we are experiencing, of course it will improve, I'm sure, in the coming years. I wanted to ask through you, Madam Chair, to the Attorney General, whether persons who are involved in the use of dangerous drugs, as well as the use of violence, whether those persons should be denied access to cash bail. In other words, in its forms that you have advance and be subject to what the magistrates and the judges would put on as, property and surety if they decide to go that route. Because we am seeing some possible dangers emerging in that department, both in terms of the use of violence and dangerous drugs, particularly the drug trade that we know is so prevalent in our country, and whether we will not be opening a Pandora's box to allow these people to access cash bail easily. So that is why I was suggesting that you may want to consider that. Madam Chair, through you.
Madam Chair. Madam Chair, I think that there are marital issues in some camps. Some people are not prepared to go home yet. I'm just teasing. It's a very, very important point raised by my learned colleague. Very, very. Why would one want to allow cash where you're dealing with a cash-rich person prone to violence? I think it's a very wise observation. It's with that in mind, I think that the amendment which came to the fore as a result of the combined efforts led by Senator Heath have helped us a bit. Because in adding that other forms of security or combinations thereof, I think that we can have some layering protection there. And secondly, the judiciary has been, as I mentioned a little while earlier, we've been in active discussions because the Bail Act is really on, even though I've said that there's a need of some reform, it actually has all of the hallmarks of why you should never be granted bail in certain circumstances. When you look at section 6(2)(a) to G, there are some circumstances there where some people should never get bail because the court has the discretion. And it is in that approach of the practice directions that we believe the judiciary can get it right.
Well, Madam Chair, I want to tell my good friend,
I take
the
back
Honorable Attorney General,
any difficulties my friend is about to report on. I take them back.
That any challenges we may face, he would not be exculpated from any direct responsibility.
Honourable Senators, the question is that the bill as amended be now reported to the Senate. Those in favour say aye. Aye. Those against say no. The ayes have it. The bill as amended will now be reported to the Senate. Attorney General.
Madam Chair. Madam President, I wish to report that a bill entitled An Act to Amend the Bail Act, Chapter 460, was considered in committee and was approved with amendments. I now beg to move that the Senate agree with the committee's report pursuant to Standing Order 69-1.
Honourable Senators, the question is that this Senate agree with the committee's report on a bill entitled An Act to Amend the Bail Act, Chapter 460. Those in favour say aye. Aye. Those against say no. The ayes have it. Attorney General.
Madam Chair, of course, Madam President, of course, taking the opportunity to profusely thank everyone, including yourself, for the excellent work done. I now beg to move that a bill entitled An Act to Amend the Bail Act, Chapter 460, be forthwith read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Amend the Bail Act, Chapter 460, be now read a third time and passed. Those in favour say aye. Aye. Those against say no. The ayes have it.
A bill entitled An Act to Amend the Bail Act, Chapter 460.
Leader of Government Business.
Madam President, I beg to move that the Senate do now adjourn to a date to be fixed.
Sign die.
Sign die. Sign a die.
He did not trust himself.
But Madam President, before I take my seat, I just want... I know, but if I take my seat, I just want to say that we are doing the mandatory break now for but I don't want to call it a summer break, but that's what it is, the vacation. And I just want to thank all senators for the hard work we have put down, even though Parliament has not prorogued officially. And I want to especially thank the opposition and the independents in particular, especially over the last 2 months, where I in conjunction with the AG, I myself as leader of government business was pushing very hard, where we were meeting twice a week. And I know sometimes it was a strain on people who are not full-time ministers or senators, and they have their full-time jobs otherwise. And we were really making great demands on their time. And I really want to thank them most sincerely. And I want to wish everybody a happy vacation. And for those of you who are traveling, safe trip.
Now, after those very lovely words by the Leader of Government Business, and before I put the motion to adjourn, there is a matter on the adjournment. Senator Mark.
Thank you very much, Madam. Yes, Madam President. Madam President, I am very happy to raise a matter involving a very critical issue affecting Petrotrin. Some time ago, on the Ministry of Energy and Energy Industry website appeared what is called a competitive bid round 2017 nomination process. And it dealt with what is called the nomination process for competitive bid round 2017. And one of the things that it outlined had to do with all open acreage, both onshore and offshore, are eligible for nomination. Now, this caused a reaction from the OWTU, and there was a headline in the newspapers Saturday, July the 1st, 2017, in which the OWTU, the headline was, OWTU don't sell energy assets. And they accused the government of surreptitiously leasing out the lucrative operation of state-owned Petrotrin, and has warned that an aggressive mobilization campaign will be mounted against such a move. In that same papers, Madam President, Saturday, July the 1st, Trinidad Guardian, we had the Honorable Minister of Energy indicating that that matter of putting Petrotrin acreage out for bid was not anything new, and maybe it might have been a misinterpretation on the part of the OWTU. He went on further to say, that article stated rather, that Petrotrin has its acreage and has a responsibility to develop its acreage, and also has a responsibility to its shareholder. In another article dated July the 1st, Saturday Express, the Honorable Minister of Energy indicated that Petrotrin will be proceeding. Well, first of all, he said, or it is stated in this article, that Petrotrin does not have the license for the deep acreage. That license was not renewed in 2006. So since 2006, Petrotrin does not have the right for the deep acreage in its core assets. And I guess it's against that background that the Ministry of Energy decided to issue what is called a bid round for nomination. Now, Madam President, I would like to say that it is a fact that Petrotrin does not have a license for the deep rights. We know that at this time, the onshore acreage that is being put out is the deep rights under the Petrotrin acreage. And that is to say, Madam President, that anything below 6,000 feet does not belong to Petrotrin. And it belongs to the people of the Republic of Trinidad and Tobago. The question that has to be asked is that in 2005, when the Ministry of Energy gave Petrotrin licenses for the land acreage, they only provided Petrotrin with shallow rights, that is 6,000 feet and above and not under. And Petrotrin, as I understand, Madam President, has been in discussions with the Ministry of Energy and Energy Industry for the deep rights for some time now. It seems to us that the Ministry of Energy and Energy Industry has decided to terminate these discussions with Petrotrin and to put the deeper rights out for nomination. The question is, why? The issue of giving one company deep rights and another shallow rights creates confusion and is hard to administer. And I believe, Madam President, ideally, since Petrotrin is the operator for the shallow rights, the ministry under the Honorable Minister should have considered giving the deeper rights to Petrotrin. But the ministry, for some reason known to itself, and the minister, for some reason known to himself, have decided to put it out for nomination. Now, this decision to put these deeper rights out for nomination could be seen as an indirect route to privatize a state asset that should have been awarded to Petrotrin. Now, we know that there are certain private operators who are PNM financiers involved in this thing called, Madam President, I would call it, it is called incremental production service companies. And we don't know if the Minister of Energy and Energy Industries has taken a decision to deny Petrotrin the rights to engage in deep rights in order to favor certain persons or companies who might be lease operators, who might be in the farm out operators, who might be involved in incremental production service companies. I know of one, and I know the minister is conscious of that particular company. For the time being, I for the time being, I'm going to withhold the name of that company. And the reason why I'm going to withhold that name, the information I'm getting, I don't want to believe it. I want to see when the second round comes around, Madam President, and they actually farm out acreages. I want to see if this particular company that the Minister of Energy and Energy Industry is very well aware of, and the Minister of Local Government and Rural Development is well acquainted with. And I think the Prime Minister is also well acquainted with this particular company located in South Trinidad so I I am going to withhold that name, which I have before me now, for the time being. For the time being, Madam President. So the question that I am asking the minister is to come clean. Is this an attempt to privatize Petrotrin? That is what we want to know, Madam President. And why, Madam President, did the minister not grant a license to Petrotrin to deal with deeper rights? Because it's already involved in the shallow rights, Madam President. As I said, if the mandate, Madam President, is to increase Petrotrin production, then why give away these deep rights, Madam President? Why cut off Petrotrin's legs, Madam President? By only giving the company shallow rights, what the government is doing is tying the company's hands behind its back.
Your time is up.
I thank you very much, Madam President.
Minister of Energy and Energy Industry.
Thank you very much, Madam President. Madam President, I don't want to pull Senator Small in the debate, but I saw him shaking his head. Because, Madam President, the competitive bid round is where the state, as a matter of policy for many, many decades, continues to put out open acreage for competitive bid, so the exploration and production concepts continue to be articulated. Madam President, in the exploration production business, which I must say I'm versed in, there's national production decline. The phrase I like to use, it's like walking up a down escalator. Because you walk up 3 treaders and the escalator comes down 3. So just to stay where you are, because production declines naturally 10 to 15% per annum. So just to stay where you are, you have to put new acreage on the market and to get companies to bid, to explore, to search and find for oil. This bid round identifies all the open acreage in Trinidad and Tobago. It includes land acreage, it includes near shore, it includes offshore, and it includes the deep water blocks. There was a bid round in 2010. There was a bid round in 2013. There was a bid round in 2015 in which deep water blocks were given out. And there's nothing, this bid round has absolutely nothing to do with Petrotrin. Petrotrin has its own challenges, which I wouldn't go into today. But the deep rights, and to correct you, Senator Mark, the deep rights is not about 6,000 feet. The difference between shallow and deep is a geological division, not a geographic division. So it has to do with the mid-Miocene and older, it has to deal with the Cretaceous, it has to deal with the Oligocene, the Eocene, and all these geological time markers. And when you just do not give a company acreage like that. When the companies, Madam President, when you put acreage for...
No, Senator Amin, members on the government bench to whom Senator Amin is addressing, would you all please desist and let the minister finish his contribution?
Madam President, you do not just give acreage. You bid for acreage, and what you bid a work program. If you give a company acreage and they just sit on the acreage, it is of no value to the state. You need a work program that includes seismic, it includes exploration drilling, and if you are successful, it will require a development program to bring oil and gas into production. So if you cannot bid and compete, and who gets the acreage is who provides the best bid, just like in any tender. So in other words, a company will bid so much square kilometers of seismic, I will drill 6 exploration wells. And if a company gives you half that seismic coverage and no exploration wells, obviously the one who plans to drill all the wells, they will have a budget and say, I will spend $50 million in exploration. And then the other part of the evaluation is technology. Because what you need to find oil, Madam President, and I was a good oil finder in my days, you need technology and you need creativity in the science. You need good geoscientists, you need good geophysicists, you need good geologists, you need good petroleum geologists. And most important, you need the technology. The technology today, Madam President, has mushroomed into unbelievable potential. Seismic technology has improved to such an extent that imaging the subsurface, as I said, seismic has moved the way of medicine. You know, there's a time in medicine, if a doctor has to diagnose you, he has to take a torchlight and put it in your eye to watch something there and something in your ear. What he was trying to do is relate to some blood vessel here that may tell him you have a tumor. Today there's something called MRI and CT scan. It's imaging. And seismic technology images the subsurface. And it images where oil and gas is. And the more robust that technology is. Madam President, seismic technology is the world's largest user of computer power outside of the US military. And in Trinidad and Tobago, we have geophysicists in particular and geologists playing with that data set and that volume of data and constructively searching for new oil and gas reserves. BP just found 2 fairly significant gas fields. They were all found by Trinidadians working right in Houston, some of them in London, and most of them around the Queen's Park Savannah. If this country is to survive, we have to continue the search for oil and gas and to diversify the economy, which is in the charge of my colleague here, Minister of Trade and Enterprise. And we have to forget this foolishness about who gets in this, who gets in. This is an international competitive bidong. The people who will be bidding here will be the top oil companies and gas companies and energy companies in the world. It will include BP, it will include Shell, it will include Exxon, it will include BHP, it will include Chevron, it will include small players also, because some of the land acreage calls for smaller players. And for the first time in this country, under the PNM administration, where we brought out the lease operatorship and farm out program, we got local entrepreneurs to invest in the energy sector. I want to quote Lease Operators Limited, which is the Brashes group of company. They own Well Services Limited. They have a company called Lease Operators Limited that is producing virtually 5,000 barrels of crude onshore. They have invested millions and millions of dollars. Senator Mark, some time ago, saying they are PNM financiers. Foolishness. They are businessmen seeking the interests of their business and the people of Trinidad and Tobago.
Why you like that?
And why?
Why you like that?
We must vilify people who are investing their hard-earned capital into producing in the energy sector. The lease operators and farm out, Madam President, produces oil, and most of those things are sub-licenses from Petrotrin. They pay 12.5% royalties. Then they pay a further 20% overriding royalty to Petrotrin. Then they pay $2 operating fee per barrel of oil produced. So that means 37% of their revenue comes off the top. Where in the world will your gross revenue be 37% taken out from the top, and they still make a profit? And Petrotrin, getting all that. I don't want to say where Petrotrin is today. So we have to understand that the state, this is a state patrimony, and the state gets money from its patrimony through royalties and taxes. And everybody pays royalties and taxes, whether you're a state company or a foreign company. And if you are a state company and you're profitable, there's another source of revenue for the government, which is dividends. So obviously it will be better for us if we have profitable state enterprises, because they'll pay royalties, they'll pay PPT, they'll pay SPT, and then you still have a chance to get dividend payments from the state. So, Madam President, this whole issue of the state trying to sell out Petrotrin is a fallacy. It is propaganda, and it is absolutely not rooted in fact. This bid round is a competitive bid round where, despite the trying times in the energy sector, we are going out to the market to see if we can get bids for open acreage throughout Trinidad and Tobago to sustain the energy sector in the long term. I thank you, Madam President.
Honorable Senators, the question is that the Senate do now adjourn to a date to be fixed. Those in favor say aye. Aye. Those against say no. The ayes have it. The Senate now stands adjourned to a date to be fixed.